Good morning, everybody. Welcome to today's meeting of the Maryland Public Service Commission. We have a number of items on the docket this morning, and we have a large crowd, so thank you for joining us. We'll get right to it, beginning with approval of the minutes of August 21st, 2019. All in favor? Aye. Any opposed? The minutes are approved. Madam Secretary, why don't we begin with the consent agenda?
Yes, Mr. Chairman. On the consent agenda, the first item is Blue Delta Energy, LLC, on behalf of the City of Danville, Virginia, Department of Utilities, filed on July 30, 2019, an application for the Pinnacles Hydropower Plant as a Tier 1 renewable energy facility for the Maryland Renewable Energy Portfolio Standard Program. Item 2 is Lexus Power, LLC, filed on July 8, 2019, an application for a license to supply electricity or electric generation services in Maryland. Item 3 is Envision Energy Advisors, LLC, filed on July 11, 2019, an application for a license to supply electricity or electric generation services in Maryland. Item 4 is Everyday Energy, LLC, DBA Energy Rewards, filed on July 30, 2019. Its notice regarding upstream change in ownership and change to non-material information provided in original application and last annual report. Items 5, 6, and 7 are also a notice regarding upstream changes in ownership and change to non-material information provided in original application and last annual report. Number 5 was filed by Viridian Energy, PA, LLC, on July 30, 2019. Item 6 is Public Power, LLC, filed on July 30, 2019. And item 7 is Triangle Energy, LP, filed on July 30, 2019.
Thank you. Do commissioners have questions on the consent items? Commissioner O'Donnell.
Mr. Chairman, I apologize, but I do have a few questions today on some of these items. On the first item, I just wondered if staff could confirm that this facility that's applying for renewable energy credits and certification is a 1938 dam in Virginia. Is that correct?
Good morning, Commissioners. Chairman Michael Jang on behalf of staff. Yes, that is true.
1938, and they're just applying to take rec money out of Maryland now. But they're in accordance with our law, right?
Yes.
Okay, very good. I just wanted to ask about that, make sure I understood it correctly. The second item, Mr. Chairman, I wanted to ask about regards to Lexus Power. And on the buck sheet, it says that the company currently provides electricity service in Texas and has sufficient experience in the energy industry. But as I read the background material, they've only been in existence since April of this year. Is that correct?
Yes, that is true.
So what is they have sufficient experience in the energy industry based upon?
So the two owners have been part of other electric companies in their past experience, basically.
And then, fair enough, the next one down, the company provides electricity service in Texas, but the Texas Commission does not regulate brokers. So in Maryland, we have the Office of the Attorney General has the Consumer Protection Division, and of course there's a Better Business Bureau, I think, in just about every state. Do we typically, in situations where they're not regulated by the Public Service Commission, check those sources?
We will be doing that. So for this company, the owners were previously engaged in other companies that did do business in Maryland, and there were no complaints against those companies.
Okay, fair enough. Thank you. I want to make sure we availed ourselves of other resources when they weren't regulated by the Utility Commission in that particular state. And then lastly, Mr. Chairman, and I apologize for this, but items 4 through 7 on the consent agenda, is there a representative from those companies here today?
Good morning, Chairman, Commissioners. Eric Wallace with Green Herlocker here, and I'm not specifically here on behalf of those companies. I am here on behalf of Maryland Gas and Electric, which is the next item, number 8. They are all part of a similar. Vistra Energy acquired Prius Energy, and so these notice filings were made as a result of that transaction. So they're sort of related. So I'm happy to answer any questions.
So all of these companies, and including item 8 that we get to later, they're all subsidiaries of the same holding company or parent company, correct?
That's my understanding.
So my question is this, and I appreciate you coming forward. I know you don't represent these companies, but all of these companies have the same essential filing that makes everything confidential. Do you know why that is, including complaints that have been made against these companies? Why is that information confidential? Or a simple listing of your officers?
And Mr. Wallace, before you answer Commissioner O'Donnell's question, can I just clarify, are you representing these parties in items 4 through 7?
Well, I'm representing. I've spoken with the folks from Maryland Gas and Electric, and Creus. So I haven't. I'm not as familiar with the other companies, and I'm not appearing
Fair.
on behalf of them.
Fair
but
enough.
To the extent that you have questions about the general transaction,
I can hold my question to item 8 because you do represent there, and it will apply there as well. So I'll hold my question till there. Sorry, Mr. Chairman.
No, I appreciate that, Commissioner O'Donnell. I just wanted to be certain who Mr. Wallace represents. So to be clear, we don't have any counsel of record for items 4, 5, 6, or 7. Madam Secretary, do we know if the counsel for these items received affirmative notice?
These are posted on our website for the hearing, but we do not send specific notices to each party that it is going to appear on the admin, other than the comments from the staff is mailed to the parties, so they would receive it that way.
Okay, thank you, Madam Secretary. Well, obviously there are some outstanding questions that will be asked with regards to item number 8 as well, but having no representative to answer these questions.
Mr. Chairman, let me just say this with regard to the items I asked about. I'm prepared to support them because I don't have a substantive reason not to today. But I am concerned about the lack of transparency in these filings. There's information filed here, like a simple listing of officers of the company and their title that is filed as confidential. I find that offensive to the public, having information that's kind of shielded. I don't know why that's shielded, and I wanted to kind of send that message that this commissioner is always in favor of transparency when it's appropriate. And in this instance, much of this information should not have been shielded from the public record.
Now, you raise a very good point. I wish I could answer on behalf of Istra Energy why all of this information is either redacted or kept from the public view. As you said, in my reviewing this confidential information, I do not see the need to keep this this public or private. So I would actually diverge with you, Commissioner, and I see no reason why this should be kept non-public, and I would support not voting on these orders at this time, but I would defer to my fellow commissioners if there are any additional questions on items 4 through 7. Commissioner Linton.
Thank you, Mr. Chairman. I actually do not have a question, but I would agree with you for items number 4 through 7. I understand that the proposed motion at this point, based on the way our statute and regulations read, is that we would simply note or acknowledge that the filing's been made. But clearly there's the consumers and the public has a need to know that information, and everything that's noted in there is confidential now. Theirs doesn't have to be.
Correct. I agree with you on that point, Commissioner.
And I would just add, I agree with everything that's been said, and I would just like the opportunity to meet the company that's going to be taking these 5 companies over and find out a little bit about, are they, manage them, how they oversee quality and ensure, customer, service and that type of thing. So I think I would support you, and let's hold this to a future date.
I would propose that we defer action on items 4, 5, 6, and 7 to a future administrative meeting on the administrative agenda to have an opportunity to speak with a representative from the company or counsel for the company. Do the commissioners support that idea?
Yes.
Okay. Madam Secretary, we will defer action on items 4 through 7 to to a future administrative meeting, subject to appearance of counsel for these companies.
Do you wish to have a letter order issued to council or to the, is it to the individual companies, or do you want to talk to the new owner?
Counsel of record is sufficient. I'm not sure if it's all the same counsel for each of the 4 companies, but yes, a brief letter order to those companies would be requested.
It will be done.
Thank you. Mr. Wallace, why don't you just stay right there?
Do you have a motion?
Oh, yes. Motion to defer action on items 4, 5, 6, and 7 to a future administrative meeting.
And 1, 2, and 3?
And with regards to items 1, 2, and 3, is there a motion?
Yes, Mr. Chairman. I would move that for item number 1, we approve the application and issue a Renewable Energy Facility ID certification number. Direct the applicant to establish a REC account with PJM GATS within 30 days of certification and file an on-site and behind-the-meter generation report with the Commission within 1 week of each recording of generation data with GATS, and direct the applicant to file notice with the Commission within 30 days of any changes to the information in the application. And for items number 2 and 3, I move that we grant the company a license to operate as an electricity supplier in Maryland, limited to broker services, for the customer classes and service territories applied for and recommended by staff. That we direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff 30 days prior to utilization of the materials in Maryland, and direct the company to file notice with the Commission within 30 days of any changes to information in the application.
Thank you. All in favor? Any opposed? The motions are approved.
Turning to the administrative agenda, item 8 is U.S. Gas and Electric, Inc. doing business as Maryland Gas and Electric, and Energy Service Providers, Inc. doing business as Maryland Gas and Electric, filed on July 30, 2019, notice regarding upstream change in ownership and change to non-material information provided in original application and last annual report.
Good morning, Chairman and Commissioners. Peter Wilson on behalf of staff. This is a notice filed by U.S. Gas and Electric, Inc. and Energy Services Providers, both of whom do business in Maryland as Maryland Gas and Electric, of the acquisition of their parent company, Prius Energy Trust, by Vistra Energy Corporation and ultimately by its parent, TXU Energy. This is the same transaction which you just this is part of the same transaction which you were just considering with the 4 other Crius-owned, formerly Crius-owned Maryland suppliers the Commission just looked at. The acquisition was completed in July, but the transaction was publicly announced in February of 2019. Of course, in May of this year, staff filed a show cause complaint against Maryland Gas and Electric, which is now case number 9615. Clearly, the acquisition was not done in response to that show cause, but was in the works before the show cause was filed. These filings were filed by all filed by the same attorney for those 5 companies, and it was not local counsel, but their compliance officer, who is also an attorney. I did not speak with her, but I did speak with Brian Green, who's associated with Mr. Wallace, and discussed the effect of the transaction, the change of ownership, on Maryland Gas and Electric, and how that may affect the proceeding currently in process against them. Some of the company's personnel has been replaced as a result of this transaction, but others remain in place, and Mr. Green and I did not see that it was going to have any material effect on the prosecution of this case. Staff's recommendation is and remains that the filing be noted by the commission.
Thank you, Mr. Wilson. Mr. Wallace, and could you explain who you represent here?
Yes, Your Honor. I spoke with that my client is U.S. Gas and Electric, Inc. and Energy Services Providers, Inc., which both do business as Maryland Gas and Electric here in Maryland. They are a subsidiary of, they're within the family tree of the group of companies that were acquired by Vistra Energy in this transaction. And in light of, we saw that this particular item was on the was not on the consent agenda, so I spoke with them yesterday and let them know that I would be here for another matter and that I could make myself available to answer any questions. And if there's anything I'm not able to answer today, I'm certainly happy to take it back to the company and provide additional information regarding this transaction or any other questions that the commission has.
Okay. Well, I suspect you'll be in a position to answer some of Commissioner O'Donnell's questions in a moment, but let me ask staff counsel first. Your buck sheet states that as of August 16th, the company has, MDG&E has 6 open complaints. What's the entire universe of complaints that we currently have with respect to MDG&E?
If I could defer that to our analyst.
Yes, so in the past, since 2016, the company has had about 220 complaints against it, filed against it.
How many?
220,
220 complaints since
2016.
16, okay. Had a representative from Vistra appeared today, I would have asked them whether or not they knew about the history of MDG&E. At this point, we have the 6 open complaints. Mr. Wilson noted the proceeding that is currently before the commission, currently before the administrative law judges, which is proceeding with respect to U.S. Gas doing business as Maryland Gas and Electric. That, at first glance, seems to be a relatively high number in my opinion here, and I'm curious to know whether or not Vistra was aware of that prior to the acquisition. But I may not ever get the response to that question. Commissioner O'Donnell.
Thank you, Mr. Chairman. So thank you for being here today. Appreciate it. You heard me ask, actually I think I just made a statement, but ask about the kind of confidential nature of these filings, appendixes A through D, which is the substance of the information on the specific companies, without getting into the detail of any of those attachments. And I don't want to disclose any confidential information because that means we'd have to empty this room out and turn our video equipment off and really, go dark with regard to these discussions. That's the effect of a confidential filing, and I don't want to do that. But I want to see kind of why a list of company officers or a kind of generic org chart, or as attachment B or attachment C, which is a list of companies doing business under the umbrella of the parent company where they do business, which is kind of long. And appendix D, which is really of concern to this commission recently, is a list of complaints which are significant in nature and what those complaints are. Why is all that confidential?
Commissioner O'Donnell, I don't know why certain information in this filing was marked confidential. What I could offer to do is I could go back to the company and let them know these concerns, and perhaps we could refile and modify some of the redactions in this notice to make some more of this information public, that and at least have a conversation about why certain information was marked confidential, and see if that would be helpful.
Yeah, I mean, I'm not suggesting there's anything kind of clandestine in these documents. I believe there's not. But anytime you mark something confidential that the public can't see unnecessarily, it creates questions in people's minds that shouldn't be created, maybe. 2, it appears that there's something going on. 3, we ought to save that confidential designation for stuff that's really, truly confidential. That way it's not kind of cheapened and used haphazardly. I think the general feeling of this state, we have sunshine laws, we have public open meetings laws, and the state is very geared towards protecting the right of the public to have as much information as possible while not compromising company specific information. So I, for one, would appreciate that inquiry and bringing that information back to us. I didn't come into the room today prepared necessarily to request these items been delayed, but you saw what we did to the first 6 items on that basis, or first whatever those numbers were, 5 items. So
Yeah, I absolutely understand your concern. I suspect that these were marked the way they were out of an abundance of caution, and that these filings were made not just in Maryland but in all of the other states where these companies operate.
yeah, that may operate great for those companies, but it doesn't operate so well for in other words, the default should be to the citizens of the state of Maryland, not to these corporate entities.
Absolutely understand, and I'll convey that to the company and talk to them about this issue, and I'll also be sure to convey that to the other clients and suppliers that our firm works with on future matters.
Thank you.
Based on that discussion, unless the commissioners have additional questions of Mr. Wallace, I would recommend that we group item number 8 with items 4 through 7 and defer and await a response from council as to why the entire filing, except for the transmittal letter, has been designated as confidential.
I agree with the deferral, Mr. Chairman. I think there are some additional questions with respect to the ongoing complaint proceeding that would be, I would like to have someone from Vista Energy prepared to respond to questions about the ongoing complaint matter and the parent support of the entity, and that's the subject of that complaint. So I was just expanding that.
Yes, yeah, noted, Commissioner Herman. Commissioner Linton?
Yes, Mr. Chairman, I would concur with Commissioner Herman. I'd also like to hear a little more about Vistra Energy itself. It doesn't appear as though they have a license in Maryland currently, independent of the entities that they're acquiring. And perhaps they could provide some background about that and just their overall contacts with the state as a whole. They're going to, as part of this acquisition, they'll own several companies or licenses to operate in Maryland, and so it'd be useful to know a little more about who's now doing business in Maryland.
Okay, Mr. Wallace, if you could take that back to your client, Office of the Executive Secretary will send out a letter to follow.
Thank you, will do.
Thank you. So the motion by the commission has just been described. We'll defer this, awaiting the appearance of counsel for Vistra Energy at a future administrative meeting.
Item number 9 is Mattawoman Energy Center, LLC, filed on May 22nd, 2019, request for modification of Mattawoman Energy Center, CPCN, case number 9330.
Good morning, Chairman, Commissioners. Michael Dean on behalf of staff. Item number 9 is a request filed by Mattawoman Energy LLC to amend its certificate of public convenience and necessity to construct a 1,038 megawatt generating station in Prince George's County. The Commission in Order number 87243 in 2015 granted a certificate of public convenience and necessity to construct this generating station. And typically, the criteria specified in Public Utilities Section 7-205 and 7-206 are used to determine whether a proposed modification to a generating station would require a new certificate of public convenience and necessity. Section 7-205A2 states that a modification that would require a certificate of public convenience and necessity would not include a change to the facility that the Commission determines will not result in an increase in air emissions from the plant or a new generating state unit of that plant. The proposed modifications to Mattawoman include conversion of a cooling tower to an air-cooled condenser, which would eliminate the need for an off-site water line, updating the rating of the combustion turbines from 286 to 313.7 megawatts, increasing the size of the diesel emergency generator from 1,190 to 2,206 horsepower, and increasing the rating of the auxiliary boiler from 42 to 72 million BTU per hour. The Power Plant Research Program and the Maryland Department of the Environment have reviewed the proposed changes and determined, after conducting an independent study of the air quality impact, that the proposed changes would not substantively affect the proposed project's modeled impacts on air quality. However, the state agencies determined that several of the conditions to the Certificate of Public Convenience and Necessity should be updated to reflect the proposed changes to the project. As directed by the Commission, a public hearing was held on June 7, 2019 to receive public comments regarding the proposed changes to the project. Staff notes that several of the comments suggested that a new proceeding for a Certificate of Public Convenience and Necessity should be conducted for the proposed changes. However, under the statute, since the Power Plant Research Program and the Maryland Department of the Environment, as discussed in their filing, have determined that these changes would not substantively increase the air emissions, staff concludes that a new Certificate of Public Convenience and Necessity would not be required for the proposed changes. Lastly, staff notes that the caption for case number 9330 should be updated to reflect the upgraded nominal generating capacity of 1,038 megawatts. Staff recommends that the Commission determine that the changes do not constitute a modification as used under Public Utilities Section 7-205 that would require a new Certificate of Public Convenience and Necessity, and to revise the case caption and approve the amended Certificate of Public Convenience and Necessity subject to the revised conditions proposed by the Power Plant Research Program and the Maryland Department of the Environment in their filing.
Thank you, Counselor. Do we have any comments from state agencies? Mr. Towson, if you want to move to the right.
Good morning, Chairman, Commissioners. Steve Tolson, Counsel for the Power Plant Research Program. I don't believe we have any comments at this time, but we do have one correction to make on the record, and Mr. Fred Kelly from PPRP is here to address that. We also have with us today Bill Paul from the Maryland Department of the Environment, who handles the air emissions issues, should there be questions on that. So I'll turn the mic over to Mr. Kelly.
Thank you. Good morning, Mr. Kelly.
Yeah, good morning, Commissioners. Just wanted to acknowledge one correction to the applicant filed a red line copy of the condition changes as well as a clean copy. In looking through that, we noted that there were a set of conditions that were added through a previous admin meeting affecting the construction dewatering associated with the reclaimed water line. So there are conditions P 1 through 13 filed on January 31st, 2017. Those should also be struck. So we can follow up in the docket and file a clean copy and red line copy acknowledging the striking of those 13 conditions.
And Mr. Kelly, they would be struck because under the proposed changes, there would be no need for that line?
That's correct.
Okay. Thank you, Mr. Kelly. Seeing no other state agencies wishing to speak, are there any other parties or members of the public that wish to speak? Okay, if we could just slowly line up at the podium to your right, and we'll go one at a time.
Podium.
And if you could begin by please stating and spelling your name for the record.
I presume this microphone is on. Okay. My name is Dr. Henry Cole, a resident of Upper Marlboro, Maryland. And It's Henry, C-O-L-E. And I want to thank the Chairman Stanek and commissioners for the opportunity to address you on what we regard as a very serious matter. I want to point out that we have 7 other community members here who have interrupted their busy schedule to come all the way up to Baltimore this morning, and some of them will make comments. On May 21st, 2019, Mattawoman LLC applied for a modification to its 2015 CPCN. The company states that the proposed changes, quote, will not result in increase or adverse environmental impacts. Although the plant changes may be minor, the Commission's approval would add tens of millions of tons of greenhouse gases over the plant's operation for over 30 years. The overwhelming evidence cannot be denied. We are facing a rapid increase in the frequency and intensity of extreme weather events. Let's not forget July's heat wave, the hottest month on record. Let's not forget the severe back-to-back floods in Ellicott City and the impact of rising water levels on our coastal areas, including Annapolis and the Eastern Shore. Adding additional greenhouse gases contributes to the sea level rise, ocean warming, and acidification, with severe impacts on marine life and fisheries with severe economic impacts. It is clear that what seemed appropriate back in 2015 is no longer applicable given what is now known about the growing climate crisis. It's accelerating at a rate that was not known even 2 or 3 years ago. Let's keep in mind that the impacts of the plant are not static, but will grow as climate conditions continue to deteriorate. The Commission should also consider that the Maryland legislature recently enacted a requirement that the state meet a 50% renewable electricity goal by 2030. The Commission should use the opportunity of the proposed modification to impose a new condition that the Mattawoman LLC come back to the Commission with a plan to replace its fracked gas power plant with solar and/or wind facilities. This action is consistent with the Commission's mission to protect public health, safety, and the environment, and to preserve natural resources that have enormous economic value. It would help, rather than undermine, the state's ability to achieve 50% renewable energy mandate by 2030. The Commission's decision is far too important for a quick approval of this modified CPCN. At minimum, the PSC should take whatever time and resources that it needs to thoroughly reevaluate its decision in light of the worsening climate crisis. Finally, I would urge the Commission members to consider the health and safety of our children and grandchildren and for future generations. Without decisive action, the impacts of climate change will grow increasingly severe. I want to add one more point, which is that I hope the commissioners will read the letter from Senate President Miller that was sent, I believe, yesterday, who takes this matter very seriously, as you can see. Secondly, I know there's a program for allocations for credits for alternative supplies of renewable energy. However, what we really need is not a balance, but a cutback in the amount of fossil fuel-related emissions. I look forward to further investigations by this commission and the staff to consider these very serious matters. Thank you very much.
Thank you, Dr. Cole. We received your comments as well as the correspondence from Senator Miller, as you mentioned. Thank you. The next member of the public, if you could limit your comments to approximately 5 minutes.
Okay, I'll be brief. My name is William Dowling. It's my wife Joyce Dowling. We live in a historic district adjacent to the plant, which in the original filing the Mattawoman claim did not exist. And this company has had issues with transparency all along. I know we've heard commissioners here say that's important. I have responses to two of the responses to questions that they gave us. Question 4 is about the CPCN.
Is this the August 20th filing of the company?
This is the response to the questions that we recently put out.
Okay, what number?
August 26th, is that it? No.
20, okay.
Yeah, August 20th, 2019.
Okay. Question number 4?
Yes.
Okay.
They claim here that they say they were in that they were in compliance and that the CPCN remains valid. They didn't say how. As far as C4 goes, it says that the C4 expires in 3 years, which had already happened. And unless a renewal application was filed, we looked in the website, we did not see a renewal application. So it could be said that this CPC is essentially expired because they did not meet the deadline. The citizens group asked for, asked for an intervention, and we were denied an intervention because we missed the deadline. So we feel they should be held to the same standard. Second thing is, they claim, that's question number 1, I think, where they claim that there is no legal definition of size, and whether this is a major or minor modification has no legal standing. We feel it's a major modification, and since that is not legally defined, then we presume it is up to this commission to decide whether or not the number of changes made here warrants a new CPCN. We feel that it does, and we humbly respect that that you look into that and come to a decision that is in favor of the population.
Thank you, Mr. and Mrs. Dowling. We also have your comments that were filed in the record.
Good afternoon. My name's Joanne Flynn, Flynn, and I am here in support of my fellow neighbors and the residents of Brandywine. I'm very concerned about community issues, and I did bring a map today because I think a lot of times people don't look at the maps, or we get a small little map that was introduced in the amendment from the applicant, and it shows what they're planning now, but it doesn't show what was the plan. So I think it'd be good to have a comparison, but all along we have lacked information. And as Mr. Dowling just mentioned, I've been following this too for several years, these power plants. It was difficult for the citizens to find out about this process. We felt it was kept from us. And when we did find out about the second power plant, that was Mattawoman, Keys already kind of breezed through without us knowing it. Keys Energy, and I think if you were back at that time you remember. But we got it together and filed for intervention because we wanted to have the community represented. And we're the most affected group, and we were shut out of that process. They denied us intervention because of time. And now it is 4 years later. Seems like there would have been plenty of time to let the citizens have their say and review these things. I mean, we put in remarks and so forth about the water cooling that's mentioned, and they've changed that, which would have been a pretty bad thing too. But the air cooling is going to cause noise. We know that they are significantly noisier. It sounds like the only thing that has to change is the air pollution. Well, that's bad enough in itself, but the noise. This happens to be an outdated industrial property that is in the middle of the village of Brandywine, and there's residences all around. Some of them will be sandwiched between two major power plants if this power plant is approved. So I think it's time to do a relook, because this is outdated zoning and it's a noxious use. I mean, it's not so bad to have industrial use that's not quite this noxious, but it's too overwhelming for a community. So I did submit statements and testimony previously, so I hope you'll consider our views in your decision. Thank you very much.
Thank you, Ms. Flynn. We do have your written document dated August 12th on the record, as well as the comments you made at the Brandywine Fire Department on July the 23rd. I would recognize that the Commission did allow additional time to solicit the input of the public, and we had 13 people attend the public hearing on the 23rd before our Public Utility Chief Law Judge. At that hearing at the fire hall, we had 9 people speaking, including Ms. Flynn, yourself, and some others. And we've to date received, before the deadline, about 12 written comments. So I just wanted to make that clear that we've solicited public input, and I'm glad to see that we've received some, and the showing that was made here today in the effort to come to Baltimore. Good morning.
Good morning. My name is Brianna Bostic. That's Briana, 1 N, Bostic, Bostic. I'm a resident of Upper Marlboro, Maryland. Good afternoon. I'm pleased to be able to speak with you today, being able to stand alongside neighbors who frequently take their time to fight not only for what they believed in, but as the case may be, for their lives is a privilege. Recently, alongside a team of 20 different neighbors and a couple hundred others who were engaged, we advocated against the construction of a 4 million square foot Amazon warehouse in a residential neighborhood. We were successful in stopping that immediate threat. The more concerning issue is that I'm here in another room full of neighbors in front of another board of people who are supposed to be called to work to protect public safety, consider environmental impacts, and encourage public trust and confidence. Again, and I can't speak for my neighbors on this, I feel like I am begging for my life and hoping that there is some procedural technicality that will save my life, even if the civic body before me won't do it. Perhaps that is me just harping on the present. So what does the future look like for a resident in Southern Maryland? Here are a few dreadful scenarios that the Public Service Commission could prevent by halting this development. It's a familiar one. A few years from now, I give birth to a child that develops asthma as a toddler because the air quality is poor. She can't play outside without wheezing. Due to the rapid pace of climate change, it's too hot anyway. I develop respiratory illness a few years later and find it difficult to breathe, exercise, participate in recreational activity with my child, who struggles to do the same. 20 years later, the power plant is finished doing its business. We can't drink the groundwater. It's been poisoned. Same with local waterways and beaches. No swimming. Elected and appointed officials cannot be found for comment. Most of those who are responsible for allowing it to be built have passed on or moved away. They never lived near a power plant, still don't. 10 years later, when the lump is found in my lungs, I have to explain to my physician that I don't have the adequate health care coverage for treatment because my respiratory illness keeps me from working full time. Children will learn from long-form articles in history books what happened to Southern Maryland, the toxic waste site. It's the way we talk about Flint, Chernobyl, and Newark when we ask what happened. And I hope that years from now I can stand outside with my healthy child and take a deep breath to say that it didn't happen here.
Thank you, Ms. Bostic. Dr. Cole, did you have something you wanted to add?
Yes, just briefly, I wanted to back up what Brianna said about air quality. My expertise lies in the area of air pollution and modeling and dispersion and whatnot. I worked for EPA and that division that handles that for 5 years. I've served as an expert witness in many cases where air modeling, and in my opinion, the PPRP, when it did its modeling, made a terrible mistake. In fact, two mistakes. If you look at the results, you'll find that 1 hour NO2, the modeling result was 181 micrograms per cubic meter of nitrogen dioxide. The standard is 188. In other words, they're within a few percentage points of the standard. There's some problems with the way they did the modeling. Number one, they chose a background station that's 70 kilometers away in Virginia, which does not reflect the kinds of traffic levels and congestion in the immediate vicinity of Brandywine. This is a critical question because the Brandywine Elementary School is ground zero to a route that will be heavily trafficked during the construction period and will be affected by this power plant when it operates. It seems that there was one right answer for the modelers to come up with, which was below the standard, and they got it. But the way they did it, it would not stand up to scientific inquiry, in my opinion. Thank you.
Thank you, Dr. Cole. Do we have counsel for the applicant?
Good morning, Mr. Chairman, members of the Commission. My name is Ian Shavitz from the law firm of Lippis Mathias, and I am counsel for the applicant. I'm also here with Mr. Brandon Upchurch, who's Senior Vice President of Development for Panda Power Funds, and has been intimately involved with the project. We're happy to answer any questions that you may have.
Thank you. You heard a few concerns by Mr. Dowling. Can you respond to those?
Those were with respect to Mr. Dowling's concerns were...
With respect to some of your responses in the August...
Oh,
20
yes. I'm
and you have counsel behind you, perhaps chomping at the bit to respond.
Oh, that was, yes. So on the, that was condition C4. We did, in fact, the Madwoman did, in fact, file the renewal that was required in a timely manner. We've been working with MDE. That deals with, dewatering. We're waiting for the outcome of this proceeding because we didn't want to reserve large amounts of water for dewatering that would not be necessary, given that if the Commission approved this requested modification, dewatering would be reduced significantly, given the lack of deeper foundations that would have been associated with the water cooling, as well as the 9 miles of water pipeline that would not be constructed if the Commission were to approve the modification.
Thank you. Do the commissioners have questions of any of the parties or counsel for Madwoman? Commissioner O'Donnell.
Thank you, Mr. Chairman. I wanted to ask, let me start with staff since they're at the hob, so to speak. Just to make sure I understand, the increase of the rated capacity goes from 859 megawatts to 1038 megawatts. How is that done? How is that upgrade performed? In other words, I've seen electrical upgrades, I've seen thermal upgrades. I'm asking, how is this upgrade of power done?
Good morning, Commissioners, Chairman. Kevin Zong with the staff. This number was simply taken from the PJMQ that was found on the PJM website as a result of the applicants having a renewed interconnection application. My understanding is that this is as a result of the increased nominal capacity of those combustion turbines, as the ratings from previously were conservative, as the turbines were in the earlier stages of development.
Yeah, so I really what I'm asking is the thermal efficiency changing in this plant to create the upgrade, the for the engineers in the world, the former nuclear guy, the Carnot efficiency of this plant changing, or is it the combustion process itself? What's changing here to upgrade this electrical output?
I was speaking from my knowledge of the thermal processes. I tend to agree with you. I think the analysis from PPRP already indicates that there's no increase of air pollution, or hence the fuel combustion amount was not increased, and the explanation for your capacity or nominal capacity increase would be improved efficiency.
It looks like the plant.
Yes, thank you. This is the same exact turbine, same exact equipment, and as staff has indicated, it is when we originally filed the application, it was at an earlier stage. We've been working with the manufacturer, and the manufacturer's had additional experience. These turbines have been, they have more data, and essentially they have found that it's a higher nameplate rating, but the equipment is the same as what the commission approved in the CPCN.
Okay, so it's the combustion cycle is going to be the same, and it's going to have a higher rated capacity output due to some sharpening of the pencils and maybe some other stuff going on there.
That's exactly right.
Okay,
Yes,
good. That's important. That's important for me to know that, because I was trying to figure out how the emissions didn't increase from that change, but that the output changed by 21% from the original CPCN. So.
Yes, that is the reasoning, and I do believe that in our original application we had indicated that following our discussions with the turbine manufacturer.
Okay, and I wanted to ask either MDE or PPRP if they could. Do we want to change witnesses yet, Mr. Chairman? You want me
Let's see if do commissioners have other questions of the applicant? Okay, why don't we call up Council for Environment and DNR, PPRP.
Steve Tolson again. I have both Fred Kelly from PPRP and then again Mr. Bill Paul from MDE, who does air stuff. So between the two of them, hopefully they can address your concerns.
So could you just give me some sense of how the determination is made that there are no increase in emissions from this change overall?
I think the applicant prepared modeling, and we had a group do an independent assessment validating the air emissions with respect to that. It was a lengthy process over the course of probably 2 or 3 months to validate, to confirm exactly what they were seeing coming out of the all attributes of the project. And in the end, we agreed that the emissions were no greater and even less in some specifics with respect to some of the emissions.
So that's what I'm trying to get to. What has lessened emissions to allow this to be a no net positive increase in emissions? Because you're increasing the ox boiler output by about 70%, and we're increasing the diesel generator horsepower rating by about 100%. So
when we request that an applicant submit an application, they have to base their emissions, their calculations on what the manufacturer provides. And we make our examination, our evaluations, based on the information provided in that application. In this instance, it has been determined that the initial rating of the unit was undervalued. And so it is basically a redetermination of what that output rating should be. We have no qualm with that, because our primary concern is what is actually being discharged that could affect air quality. And the manufacturer has indicated that there is no change in those characteristics of the emissions and their quantities.
So for the combustion turbines, I got that from the company's response and staff's response from the previous question, but I'm looking for offsets for the increase in the aux boiler output and the diesel generator, the emergency diesel generator backup increased output. Are these larger machines? Are they different machines? What's changing on those machines?
In the whole scheme of things, the emissions associated with the auxiliary equipment are inconsequential. They would not change any of the requirements in terms of the state or federal rules. It wouldn't have changed the what's called the best available control technology determinations. It is after they've submitted their application, they do more fine-tuning of what their loads will be. And so they make the necessary adjustments. These pieces of equipment for which they increased the capacity, they did have increases in emissions. And those increases in emissions were provided in their resubmittal for our review. And they were taken into account in evaluating what the whole facility-wide emissions would be as a result of those changes.
Okay, and I'm sure that there was some decrease in emissions from the doing away with laying in 9 miles of dewatering pipeline. Is that safe to assume? Was there some?
Well, there are dewatering emissions. There are emissions resulting from that, but when we look at the installations that we are permitting, okay, there is a reduction in particulate matter primarily because of the switch from wet cooling to dry cooling.
Okay, well, that was important for me to at least understand a little bit. I appreciate that. So there is a no net increase from the original CPCN approval on emissions for this project.
That's correct. In fact, there's a net decrease.
Okay, very good. I just have one other quick question, Mr. Chairman. Thanks for your indulgence. And that is it's probably a typographical error. So staff says the emergency diesel generator increases from 1190 to 2260, and PPRP says increases from 1490 to 2206. What are the correct numbers so we can make sure that they're consistent with each other? It looks like two transposition, or one transposition wire, excuse me. It's either 1190 or 1490 horsepower.
It's my understanding that it's 1490.
1490, okay. Noted. We'll correct the staff buck sheet. There's probably a typographical error. All right. Just so we're consistent in the record. Thank you.
Mr. Kelly, if I could ask you a question in response to Ms. Flynn's concern regarding ambient noise. Has PPRP looked at the matter of whether or not this air-cooled technology will be louder? Presumably it would be louder than the wet-cooled technology, and what the effect would be.
Well, we've heard from the applicant that it would be no louder than what was proposed. We are still waiting, pending the two conditions affecting noise monitoring following construction of the project, and then the secondary condition that says that they should be within all noise regulations for the area.
Okay, thank you. And if in the event that the facility is constructed and the noise levels go above what was conditioned in the CPCN, what steps would the developer have to take?
I think we would have to ask them to undertake engineering exercises to reduce the noise so that it's within the regulatory limits in that area.
Thank you. Does the representative from MDE have anything additional to add?
Just a point of clarification as to how the regulation actually works. The noise program used to be under the jurisdiction of MDE until about 20 years ago. Now it is the local jurisdiction that has responsibility to respond to noise complaints. But the way the law reads, the way the regulation is stipulated, is that there has to be an exceedance of the noise level at a residential, at a point of concern, which is usually a residence. It is not at the property boundary. And you can, I guess it's up to PPRP as to whether or not that they want to make the requirements more stringent. But in terms of the statute, there are specified dB levels, and the measurement is taken not at the property boundary, but at the point of impact.
Thank you, sir. Additional questions for MDE or PPRP? No.
Just like to ask him what that dB level is and it's dBA weighted.
I don't know, only if you're able to respond, if you know what the decibel level is.
It is subject to check. It is 55 dB during the daytime, and 65 dB during the daytime before 9 p.m. and 55 dB after that.
Great. Thank you. Do the commissioners have additional questions of any of the witnesses today?
Just on your, I had the same question about the noise conditions, and so am I understanding that nothing that's being proposed here will increase the as it was put, the ambient noise of the site? Will it change at all?
From our understanding, or maybe the applicant could expand on this, but what we've heard from them is that it would be no greater than what was originally proposed.
Okay, so that even with the larger emergency generator, it would still be at the same level as proposed.
Yes, my understanding is that there are some engineering factors that could be in play that would keep the status quo.
Status quo. Okay, thank you.
Looks like he wants to say something.
Do you have anything to add, Counselor?
Excuse me. Just to confirm what was just stated, that, yes, in fact, that even with the changes, we'll continue to meet the noise requirements, the local requirements, as stated, and also to underscore the fact that if there is if there is an exceedance once constructed, that engineering would be undertaken at the plant to ensure, per the condition of the CPCN, that there are no greater noise than what is allowed under local regulation.
Thank you. Obviously, we've heard from a number of members of the interested public, the community. We've had our staff visit the site earlier this month. We've had the chief judge meet community members and take public comment in Brandywine last month. This proposal from the Panda folk was filed back in 2013. The commission at the time approved the CPCN in 2015. It was litigated. It was appealed to the Circuit Court of Maryland. The court found in favor of the developer, and before us today is whether or not to approve of this change to the CPCN. There is no question in my mind that climate change is real. We are seeing the effects in a low-lying state such as Maryland. And the state has clean energy goals, as was noted by some of the speakers, with the Clean Energy Jobs Act, moving us towards a 50% renewable standard by 2020, and the governor's efforts to move us to a 100% clean energy standard by 2040. That said, before the commission today is only one item, and that is whether or not the proposal by the applicants constitutes a modification under Section 7-205 of the Public Utilities Article. Staff's recommendation is that the three proposed changes to the systems at the site do not constitute a modification, despite that they are changes. I agree with the staff's recommendation. As we've heard today, the changes to the configuration and the site would not constitute any more adverse environmental effects than the original proposal from 2005. We've heard from the two environmental agencies that, in fact, that emissions levels will be decreased with the change in moving from air cooling to wet cooling. It would also obviate the need for this 9-mile dewatering pipeline, as well as the use of millions of gallons of water from nearby water bodies in the course of a year. For those reasons, and not diminishing any of the comments or concerns of the public, I would vote in favor of the applicant's request to modify its CPCN. Before calling a motion, do any of the other commissioners wish to comment? Is there a motion?
Yes, thank you, Mr. Chairman. I move that the commission determine the changes do not constitute a modification under Public Utilities Article Section 7-205 that will require a new CPCN, and that we revise the case caption and approve the amended CPCN subject to the revised conditions proposed by Power Plant Research Program and the Maryland Department of the Environment in their filing dated May 30, 2019, and as updated as they suggested at this hearing.
Thank you, Commissioner Herman. All in favor?
Aye.
Any opposed? The motion is approved.
The next item on the agenda is item 10, Dan's Mountain Solar LLC, filed on June 18, 2019. Deadline extension request, case number 9400.
Good morning, Mr. Chairman. Kenneth Albert on behalf of staff. This item addresses the request by Dan's Mountain Solar for an extension of the construction and operational deadlines imposed by the Commission in authorizing Dan's Mountain to construct an 18-megawatt solar photovoltaic facility in Allegheny County, Maryland. Their current construction deadline is July 2019, and the current operational deadline is July 2020. Dan's Mountain Solar asks that the construction deadline be changed to June 2022 and the operational deadline be changed to June 2023, essentially a 3-year extension. In authorizing the project in July 2016, the Commission imposed a 3-year deadline on the completion of construction and a 4-year deadline on the commencement of operations. In July, the Commission issued a temporary extension of the construction deadline until the Commission addresses the request, which we are doing here. In its request for an extension, Dan's Mountain cites the difficulty that it has encountered in ensuring that the project is financially viable. This financial challenge caused Dan's Mountain to forfeit its queue position with PJM. Dan's Mountain says that it is now working with a new financing partner and has reapplied for interconnection with PJM. PJM is currently performing a study of the interconnection with the distribution grid operated by the utility Potomac Edison. Dan's Mountain is planning to commence construction during the fourth quarter of 2020 once PJM has completed its studies. On August 23rd, 2019, PPRP filed revised conditions to apply to an extension of the construction and operation deadlines that is now being requested. The revised conditions include more comprehensive standards in connection with several issues, including soil erosion and settlement control, establishment of a pollinator habitat at the project site, decommissioning of the project, and financial security associated with decommissioning. Staff recommends that the Commission grant Dan's Mountain extension of the construction and operational deadlines contingent upon the successful completion of PJM's interconnection studies and Dan's Mountain's compliance with any revised conditions proposed by PPRP and the Maryland Department of the Environment.
Thank you, Mr. Albert. Do we have any comments from representatives from PPRP? Only if you have any, if not, none. Counsel for Dan's Mountain Solar.
Thank you, Mr. Chairman, Commissioners. David Bugelmans on behalf of Dan's Mountain Solar LLC. I have with me Mr. Howard Ulip from GRP Global, the developer of the project. I'll keep my comments brief today. Dan's Mountain concurs with staff's recommendation as reviewed and supports PPRP's revised conditions filed with the Commission on August 23rd, 2019, last Friday. We appreciate staff and PPRP's support of this extension request and are happy to answer any questions from the Commission. Thank you very much for your consideration.
That was very succinct. Thank you, Mr. Bugelmans. Any questions from the panel?
Sure, I guess.
We have some from Commissioner O'Donnell.
I hate to disappoint. Mr. Bugelmans, you had a filing on June 18th that's included in our packet. And on page 3 of that, you talk about the new interconnection agreement that's been referred to here, the second full paragraph. I would direct your attention to the last sentence of that second full paragraph. It says, PJM has indicated it will notify Dan's Mountain by the end of this month whether the request to combine the studies has been granted. Dan's Mountain will provide an update to the commission once it receives these notifications. Has that occurred?
Dan's Mountain, Your Honor, has not provided an update, but I can do so today. I'm sorry for the oversight. PJM has informed Dan's Mountain that it will not combine the studies. Dan's Mountain has received the system impact study and is proceeding with the remaining 2 studies in the PJM process at this time.
So what does that mean for this project and its viability going forward and getting a new dance partner and all that sort of stuff?
The project remains viable, Your Honor. If PJM had combined the 2 studies, it would have sped up the process and allowed the project to proceed sooner. But with the 3-year extension, it's acceptable, and the project believes we'll be able to commence construction within the deadlines.
Yeah. So the reviability of this project, you kind of pulled the Q plug, and then you stuck the Q plug back in the application back in. That wasn't predicated on these studies being combined?
It was not, Your Honor.
Okay. I am... Mr. Chairman, that's all the questions I have. I'd like to just make a comment, I think, before we're ready to act on this item, if we do act. But I'll listen to other questions.
Mr. Bugelman, you were so brief, I just want to make sure that I heard correctly, that the company is in agreement with the revised conditions that were filed with the commission on August 23rd?
That's correct, Your Honor.
Okay. I thought I heard that, but you were going so quick, I wanted to make sure.
I'm sorry I spoke so fast.
That's okay. Thank you.
Sorry, Commissioner O'Donnell, did you say you had further thoughts?
I just wanted to share my thoughts before we take action on the matter. As some observers may have been aware, I'm not a fan of the waiver to rule requirements being the rule itself, and with these solar projects, whether they're CSEGs or otherwise, it seems to be the trend that the waivers become the rule itself, and the rule becomes essentially null. I think there's a reason for having rules. I think the deadlines for construction and operability are based on many things, many considerations, not the least of which the time of the staff of the Public Service Commission of Maryland, the interagency reviews that have to occur, the PPRP, the Office of the Attorney General, and many other agencies in the state, when these projects are extended, or there's an application for extension, because that has become the rule and they're expected to be approved, that eats up resources of the state at the discretion, not of the state agencies, but it becomes the discretion of the applicant who kind of expects it. I disagree with that philosophy. I think rules should be written so that the exception or waiver is rare and doesn't put an inordinate drain on the resources of any agency in the state, which ultimately is borne by the taxpayers because this entity couldn't get its financing arrangement under the original agreement, apparently. So I am not going to support this extension. I'm going to abstain from it based on those principles just stated. I don't think there's good cause here other than they didn't get their financing, and that's not my problem.
Thank you, Commissioner O'Donnell. Seeing no other comments, is there a motion?
Yes, Mr. Chairman. For item number 10, I move we grant the company's request for an extension of the construction and operation deadlines outlined within the approved CPCN, subject to any conditions proposed by the Power Plant Research Program and Maryland Department of Environment.
Thank you. All in favor?
Aye.
Any opposed?
Opposed.
Commissioner O'Donnell is noted as opposed. Motion is approved 4-1. Thank you.
Thank you.
The next item on the agenda is Imbala Power Networks USA, Inc., filed on July 25th, 2019. A request for withdrawal of license to operate as a curtailment service and a request for an exemption from the payment of PSC assessment of payment pursuant to 2-110 of the Public Utilities Article Annotated Code of Maryland.
Thank you. And do we have counsel for Enbala? No. Mr. Albert.
Good morning again, Mr. Chairman, Commissioners. Kenny Albert on behalf of staff. This item addresses a filing by Enbala Power Networks USA, Inc. that asks the Commission to terminate Enbala's authorization to operate as a curtailment service provider. Enbala does not have any customers in Maryland, but they do owe $110 in Commission assessments. They ask the Commission to waive the unpaid assessments, but staff does not think they've provided any justification for that. So staff recommends that the Commission reject the request for the waiver of the unpaid assessments and that the Commission determine that the Commission will terminate Enbala's authorization as a curtailment service provider when Enbala pays the unpaid assessments.
Thank you. I agree with you. Do the commissioners have questions?
Is the company here?
No, the company is not present.
And just to clarify, the company did not provide any reason, any rationale for its request for a waiver of the...
Right, we
fees?
did not, no, they just simply asked for a waiver.
did.
Often we see that.
Okay, thank you.
Commissioner O'Donnell.
I was prepared to make a motion, Mr. Chairman.
Thank you.
Mr. Chairman, I move the commission direct the company to pay its outstanding assessments. Upon payment, the license will then be canceled.
Thank you. All in favor?
Aye.
The motion is approved.
The next item on the agenda is Southern Maryland Electric Cooperative, Inc., filed on August 13, 2019. Its proposed electric vehicle public charging tariff, Schedule EVPC, effective September 1, 2019.
Morning, Mr. Chairman, Commissioners. Annette Garofalo on behalf of Commission staff. By letter order dated July 31, 2019, the Commission approves SMECO's request to implement a community-owned public charging station program and directed SMECO to file a tariff governing its filing. SMECO's request and its tariff filing are consistent with Commission Order Number 88997 pertaining to implementation of a statewide electric vehicle portfolio. By its tariff, SMECO has proposed to use the same market-based rates as used by BGE, PEPCO, and Delmarva. The rates proposed under these tariffs are 18 cents per kilowatt hour for level 2 charging and 30 cents per kilowatt hour for direct current fast charging. Staff recommends the Commission adopt these rates as filed since they are consistent with similar rates accepted by the Commission for similar service. There is one omission from the tariff that staff recommends be included not only for clarity but also for consistency with the Commission Order 88997. The tariff language is that, quote, all public EV charging stations will be sited on property either owned by government entities or government-associated organizations or controlled by those entities and organizations, such as through easements, right-of-ways, or similar legal or equitable mechanisms, unquote. The cooperative agreed to include this sentence in its tariff. In order to include this language, staff recommends the Commission file a clean copy of the new tariff, and staff recommends the Commission accept for filing with the inclusion of the change proposed by staff and requires SMECO to refile clean copies of its tariff.
Thank you, Counselor. Does Office of People's Counsel wish to add anything on this matter? Mr. Sheen.
Good morning, Mr. Chairman, Commissioners. Philip Sheen on behalf of the Office of People's Counsel. We support staff's recommendation, but would also additionally request that the tariff specify that the charging stations be open 24 hours a day, 7 days a week.
Thank you. Anything further?
And that would be bring it into alignment with BGE and the other, Delmarva and the other utilities.
Thank you.
Can I ask you a question on that? Was that submitted by the companies or was it specifically ordered by the Commission? Do you know, that 24/7 requirement?
I am not sure, Commissioner. I'd have to check and get back to you.
Yeah, I mean, if it was discretionary on part of the utility and they're filing, that's one thing. But if we kind of sua sponte ordered it, that's something else to me. I'd like to know that.
Yeah, I see your point. A lot of this charging is done overnight, so it is important that they be available 24 hours a day.
Right.
Thank you.
I mean, we don't just routinely make one utility adhere to the application necessarily of another utility unless there's a good cause for that. But just because it's there is not good enough cause for me.
And I must admit, now driving an EV for about 5 or 6 months, I rarely charge up at 2 in the morning. But it appears that Most every EV station that I've seen has been available 24/7. Good morning.
Good morning, Mr. Chairman and Commissioners. I'm Mark McDougall on behalf of Southern Maryland Electric Cooperative. As staff counsel mentioned, SMECO is in accord with staff's recommendation and would be happy to add the sentence that staff recommended in our tariff filing. To answer Commissioner O'Donnell's question, I do believe that the Commission did not order the Exelon Utilities to put that particular provision that OPC has recommended in their tariffs. I believe that that was something they did independently. My review of the tariffs as they have been filed seem to indicate that Potomac Edison does not have that provision in its tariff, which led me to believe that the Commission did not order that for all the utilities. SMECO believes that it's important that not only for the pilot, but for a continuing program, that that charging stations be available to the public as much as possible. The reason that SMECO opposes OPC's suggestion is for a few reasons. First, the utility does not have control over the siting host's facilities. The siting host could be repaving a parking lot, for instance. They could be clearing snow away. But and during these processes, the charging station might not be available to the public. So to have a provision in our tariff that says that the charging station must be available to the public at all times is a provision that we necessarily can't comply with because we don't have control over that parking area. But like I say, it is important for the pilot to have these charging stations available most of the time. As a matter of fact, in our May 14th, 2019 application for approval of our pilot, as a condition to site host eligibility, we did say that EV chargers must be publicly available and not located in a restricted access area, i.e. behind a gate or something like that. So we recognize the importance of having them available. In addition to not having control over the site, and the fact that they might not be available all the time, SMECO thinks that the best way to ensure that the sites, the charging stations are available as much as possible is in the contract that we have with the site host. My intention is to include in that contract where the site host makes available parking spaces and allows the utility to put the charging stations on their property is to have a provision that the site host will keep an uninhibited access to the charging stations as much as practically possible. The tariff, as I've always interpreted, is basically a document that defines what the relationship between the utility and the customer. And in this particular case, the site host is not our customer. And so I thought that the provision that OPC is recommending ought to be included in the contract with the site host rather than our tariff.
Thank you, Mr. McDougall. Do the commissioners have questions on that point or any? Commissioner Linton.
Thank you, Mr. Chairman. I don't drive an electric vehicle, so I hadn't thought much about the requirement to charge over an extended period of time. But the point of not having it available 24/7 and instead incorporating the language into the contracts does raise several questions, at least for me, at the top of my head. And so, just as an example, we have the upcoming holiday weekend, Labor Day weekend coming up. Would you envision a situation where the charging facilities were available on a holiday weekend for example, when the government offices may be closed, but there's people visiting Southern Maryland.
Well, our intention is to site charging stations where they are accessible to the public. So, as in our application in May, our intention would be to have them sited not behind fences, but in open parking lots that are available to the public, really almost all the time, and perhaps all the time, and that would be my preference. There are many, many government facilities, whether they be schools or government administrative offices, that have open parking areas for the public all the time, even when those locations are closed. So I would anticipate that even during the holiday weekend coming up, that if we had charging stations sited at government offices during that weekend, they would be accessible to the public.
So then it's not SMECO's intention to turn off the charging stations at a certain period of time, but instead it's more based on when the consumer would be able to access the charging station. Is that really the point we're talking about?
That's exactly the point we're talking about.
All right, thank you.
Thank you, Mr. McDougall. It's my understanding that these stations will be open 24/7, absent some, like you said, snowfall, or we're not going to be placing them in a facility where there's a locked gate at 10 o'clock in the evening. Is that your understanding?
That is my understanding, Mr. Chairman.
Okay. Thank you. Thank you.
Your Honor, just a point of clarity, the BGE tariff does contain the language that OPC cites, but none of the other tariffs. Mr. Dougal mentions Potomac Edison, but the PHI companies also do not have that language, presumably for similar reasons.
Thank you, Ms. Grofflow. And I don't see the need to include the more restrictive language. The utility has stated that it's going to use best efforts to keep these open 24/7. Obviously, if there's a act of God or something that's going to prevent them, it appears that the utility doesn't want to be held liable under its tariff for having a charger out of service for a reason outside of its control. But aside from that, the intent of the utility is to have these available, open to the public year-round, 24/7. So with that, I am comfortable moving forward with staff's proposal, but not OPC's. Is there a motion?
Yes, Mr. Chairman. For item number 12, I move that we accept the tariff for filing with the inclusion of the change proposed by staff in its comments dated August 19th, 2019, and direct the company to file clean copies of the tariff with an effective date of September 1st, 2019.
Thank you. All in favor?
Aye.
Any opposed? The motion is approved.
Thank you.
Item number 13 is DOF 4, Hunt Valley Master Tenant LLC, filed on July 15, 2019, a request that the distribution interruption penalty be waived for a 12-month period.
Michael Dean again for staff. Item 13 is a filing by DOF 4 Hunt Valley Master Tenant LLC requesting a waiver of the distribution interruption penalty found in the Baltimore Gas and Electric Company gas tariff in Schedule IS for failure of the customer to cease gas usage at its facilities during a distribution system interruption day event on January 30, 2019. The tariff for Schedule IS interruptible service for large customers provides for a penalty for failure of an interruptible customer to interrupt service, but allows the Commission upon request to reduce or waive entirely the penalty for a customer who demonstrates that a good faith effort was made to interrupt its gas usage as required. The demonstration of good faith effort is to include 1, efforts made prior to the interruption to be fully compliant, 2, the reason why full compliance was not obtained, such as failure of the equipment, 3, efforts to mitigate the failure, and 4, customer efforts after the interruption be fully compliant. At 10 p.m. on January 30, 2019 to 10 a.m. on February 1, 2019, Baltimore Gas and Electric interrupted its IS and ISS customers due to large forecasted demands on its natural gas system. As discussed in staff's confidential comments, the customer was notified of the interruption and for the reasons stated failed to do so and was assessed a penalty under the tariff as specified in the comments. The customer in its filing reported its good faith efforts regarding its 4 boilers intended to be used during a distribution system interruption day. Boilers 1 and 4 were out of service awaiting final inspection to ensure their mechanical integrity. 3 hours before the start of the interruption, the customer attempted to start boiler number 2, but failed to switch over due to a failed air compressor, and boiler number 3 had a broken oil pump. During the interruption, repair attempts were attempted for the air compressor, and since boilers number 1 and 4, and since then, boilers number 1 and 4 have completed their inspections and are currently available. Staff has reviewed this filing and, as discussed in the staff comments, believes that the customer should have done more to ensure that with 2 of its boilers not operational, the other 2 boilers were inspected to ensure that they would be fully available if needed, and because it did not communicate with Baltimore Gas and Electric prior to the event regarding its difficulties, such that actions could have been taken, such as arranging for optional firm delivery service during the interruption event. For these reasons, staff recommends that the Commission deny the requested waiver of the penalty for this customer. Staff understands that the customer disagrees with the staff recommendations and believes it demonstrated a good faith efforts to comply with its obligation to interrupt under the utility tariff.
Thank you, Mr. Dean. Counsel for DOF 4 Hunt Valley Master Tenant LLC.
Good morning, Mr. Chairman, Commissioners. With me, just in case there are questions for staff, this is Lawrence Prosen with Kilpatrick Townsend. We're of record. We filed comments in response to inquiries made by staff. With me in the room is George Nakala, who's Corporate Director of Project Management and Engineering for Crescent Hotels and Resorts. He oversees all the properties, including this one, and can provide you answers any questions you have with regard to the current status, what happened at the time, and what repair efforts my client has made to assure the Commission that there won't be a repeat of this. Greg Donatel is the Director of Finance to Delta by Marriott. This is the old Hunt Valley Inn, for those of you, I know it as the Hunt Valley Inn. I didn't realize it's now a Delta property. But Mr. Donatelli is one of the people that carried over, who's been with the property for over 2.5 years. And then Jessica Mann and Shannon, who are with Eric Ryan Energy Consulting, who have interacted with Baltimore Gas and Electric. Eric Ryan's a energy consulting service that my client, who was the lender on the property and has now taken the property back through foreclosure, has worked with BG&E to try to not only rectify the situation that we're before the Commission today, but also to try to mitigate things from happening in the future. We have had talks with staff, and we have provided a detailed submittal. Also yesterday, in response to comments which I received on Monday in the mail, we did also provide, and I have copies if the Commission wishes, we had originally provided 2 certificates regarding the boilers. There's 4 boilers on the facility. We actually have all 4 now, which show that all 4 boilers had been inspected within the past 2 years, in spite of the Commission's, the staff statement that they hadn't been inspected in the previous 2 years. All 4 had been. We also confirmed with BG&E, Ms. Main did, that Ron Tessar, who was then the property engineer, the operating engineer of the boilers, had contacted BGE at 12:30 p.m. on January 18th, 2019, that the boilers, some of the boilers were down for service and maintenance. Also, BG&E is aware that there are 4 boilers on this property, but the system is designed for only 2 to operate at any one time with backups. And it's with that in mind and some of the previous matters you've heard before the court about this being a perfect storm, no pun intended in this case. This property, for the Commission's benefit, my client was the lender. They gave a significant amount of money to the prior owner of the property. As a result of that prior borrower defaulting, in August, a foreclosure action was commenced, and effective roughly September 1st, the current owner of the property took over the property. The property, as you can imagine, where there's a default situation, was not properly maintained. My client promptly had boiler inspectors come in. Their insurance company, AIG, also had inspectors come in. We've provided staff and the commission with copies of those reports. Two of the boilers were found to be out of compliance, and we were directed to take them offline. So at this time, the boilers are running on gas service. The two boilers that remained online were on gas, and when the interruption announcement came out, we did make good faith efforts. We tried to switch over from gas to oil. There was oil there. Unfortunately, as staff described it, one boiler was up and running. The air compressor, which provides the air to the flame under the oil situation, failed. We tried to fix it. Unfortunately, it didn't happen. We couldn't get it fixed. The other boiler that failed, the oil pump failed, as staff described for it. These were not foreseeable things. We had inspections in October and in December. These things were not brought to our attention by the inspector. The further complication is these are boilers from the 1970s, I believe 1974, if I'm not mistaken. They certainly had served their useful time, and we thought that they were working fine. Again, we were getting hot water, we were getting heat, and under the standard good faith efforts, as we've described in detail, and respectfully, as in going through the staff comments, there are a number of items in there that we do not agree with that we think may also affect the outcome of this decision. We feel that we have met the good faith standard on the regulations, and that the commission does have the discretion to waive, by the way, in this case, a $339,000 penalty, which to me is a remarkable number. The first, it's paid starting in May over 12 months. The first bill came out. Frankly, my client saw it, and they thought, okay, that's it. You know, a tenth of that, so roughly $30,000. When it came the next month, that's where this appeal came out of. They thought it was a one-time thing. They did not have any realization. We haven't received the calculation we've asked for from BGE. BGE did not give any formal notification, hey, your May bill is going to have a slight uptick of $30,000 to it, and oh, by the way, that'll be over the next 12 months. Most critically, though, I think it's important to realize that some of the statements in the staff report, so not intentionally, but I think are slightly misleading. So, for example, on page 4, under the first full paragraph, they state that that the boiler safety inspection on October 10th can lead to an assumption that somehow we should have been on notice that an oil pump and an air compressor were going to fail. Again, we didn't know. It wasn't until we did the switch over that happened. Another complication I should add, too, was that the two boilers that were brought out of service because of the issues, you can't go down to Home Depot and get a part for a 1974 boiler. Some of the parts had to be custom manufactured. Other parts had to be procured from other locations. And unfortunately, it took a longer period of time to get those parts. So again, in the whole scheme of this situation, it wasn't a matter of intent. My client had only owned the property for a matter of a handful of months when this happened. They are supposed to comply with the program that BGE has. They have 1 year to do that. We had only owned the property for 4 months at the time. I am told that 2 of the boilers are fully up and operational now. I think staff recognize that for both gas and, if necessary, to switch over to oil. Another one, I believe, is coming online today. We had to have a couple parts custom built. And the third one is ready to come online, except there's some water leaks that my client, before they bring them online, is going to have repaired once the third boiler is brought online, and that should be up and running. And we are already in the process of arranging with the State Department of Labor Licensing and Regulation for all the necessary boiler inspections on those units. We also will have an engineer perform the necessary testing to verify to BG&E that we will be available if it happens for a switchover upon the requisite notice. With all that in mind, Your Honor, and Your Honors, we believe that a good faith showing has happened here. Again, it was, using the terminology, a perfect storm. 2 pieces of equipment failed. 2 other pieces of equipment, when we went to switch over, failed. It was not foreseeable. There certainly was no intent. One of the other issues here is that there is, under the regulation, a prima facie case that if you exceed usage by 5%, so 105% or more, that there was not good faith showing. In the report, at one location, it states that we exceeded usage by 104%. I think that's a typo. We exceeded usage by less than 5% or 4%, not 104%. In other words, we didn't go from 100 therms to 204 therms. So from that perspective, we believe that there's been a good faith showing. We would ask that the commission waive the fee in full, and I'm prepared, and my clients here who flew in are prepared to answer any questions you have, and we thank you for your consideration.
Thank you. Counselor, you noted some dispute with the methodology used by BG&E to determine the penalty. I suspect that penalty calculation is laid out in the tariff. Have you had an opportunity to speak to BG&E?
We have asked for it, and I do not believe we've actually received it. We've tried to back into it based on the formula, but we have not actually received it. I will also tell you all that we are in talks with them about perhaps switching over from this schedule to a different tariff schedule to preclude any risk of this happening again, and that deals with them getting a capacity study to make sure that we're in that way. But we've had extensive discussions. Ms. Main in particular has had extensive discussions with BG&E over the last 4 months or longer, and I've got several emails back and forth if the commission's interested in talking with them.
Customers who opt to be on an interruptible schedule should be sophisticated enough to understand the risks that are associated with the benefit of having a much reduced distribution rate. Obviously, in situations where you take more than you're permitted or you violate the action that's requested by BG&E, in this case it was a email to Ron Tessar on January 29th notifying the hotel that it was to interrupt effective the 10 p.m. on January 30th and failed to do so. Did Mr. Tessar inform BGE that it was not going to honor BGE's request?
No, he's no longer with the company. I do not believe he did.
Okay. I'm not surprised by that detail. You did reveal the penalty is $339,000, I believe. That was confidential in the buck sheet. Since you revealed that, it's open now. There's a number of other items that remain confidential here. The status of the 4 boilers, obviously we're approaching the winter season. The letter filed by Ms. Main stated that the hotel has completed all necessary repairs to the boilers. Is that not true? Are all 4 boilers operational now and able to switch between gas and fuel oil?
We've done some additional repair work to the boilers, so and George can give you the particulars. He was just at the property. My understanding is 2 of the boilers are fully operational and can switch between gas and oil.
Okay.
The 3rd boiler is coming online today for testing. They had water tested it. There was an issue with a lid, basically a pressure lid that they've been testing. As I understand it, that boiler will be coming online today for final testing, firing up, and will then be inspected. And as I mentioned, the 4th boiler, I believe number 3 has a water leak. It can operate now, but we haven't actually brought it online because once the other boilers are online, the 2 boilers are online, the 3rd one's online, we're going to repair that one so there's no more water leak. But that will, and again, here's the director of capital improvements. I can represent to the commission. These will all be up and running, fully inspected, and again, if you want to provide more specifics.
Thank you. Do you have anything to add?
No, like we said, that we have 2 boilers, and the hotel operates on 2 boilers. They're sufficient enough for heating and hot water for guests. Right now, we have 3 ready to switch from gas to oil, and the 4th one, like he said, we're going to try to get it completed by within the next couple of weeks.
Thank you. The documentation that was provided by you clearly demonstrates that the boilers were not kept in a good state of repair. I suspect a lot of this deterioration occurred before transfership of the property transferred to your client.
That is correct, Your Honor.
the company has taken steps to make sure that this doesn't happen again, and it sounds like you're considering whether or not to transition to firm service.
Yes, Your Honor. As I understand, the inquiry has been made. I believe, and correct me if I'm wrong, I believe that BG is in the process of doing a capacity study to make sure that I guess it doesn't affect surrounding areas, but that inquiry is well along.
Who is your point of contact now that Mr. Tessar is not with the company anymore, in case BGE made a request this evening to cease taking commodity?
My name is Greg Donatelli, Donatelli. I'm the Director of Finance for the hotel. Currently, right now, I would be that contact. With that, the reason that Mr. Tessar is no longer with the company is he is out for medical issues.
He's still an employee of the company?
He is still an employee of the company, but he is out on a medical leave, and he is unable to attend.
Okay.
Due to that.
Do we know why he ignored the request of BGE?
He did not ignore the request of BGE.
What was his response to BGE when he received the email dated January 20?
Your Honor, they actually did try to do the switch over. Staff has recognized that. What happened was he got the notice, he started the switch over. One of the two boilers that were operating during the switch over, the air compressor failed. He tried to fix it and could not get it fixed. The other operator, when you switch from gas to oil, the gas is pressurized, the oil has to be pumped from the tank into the boiler. The oil pump failed. So as a result, he had to switch back. Unfortunately, because of his medical issues, we have not been able to interview him. He's been out over extended leave. So I don't know the particulars of how that component went. Did he call them up and say, hey, I can't do this? I'm not sure. I know on the 18th of January, he informed BGE that two of the boilers were down for maintenance. I do not know the particulars of the real-life events as they occurred as his contact.
And you said he notified BGE on January 18th that two boilers were out of service?
Yes, Your Honor. We provided staff yesterday with an email. I can approach if...
That's not necessary. Okay. The hotel had 36 hours notice, and the interruption was also going to last 36 hours. Does the hotel have any contingency plans to move guests in such a situation?
The notice was less than 36 hours, I believe, Your Honor. I think the shutdown was for 36 hours.
The notice was received Tuesday around noon, and the interruption was to start Wednesday at 10 p.m., so a little less than 36 hours. What's the contingency plans if this has to happen again? Do you continue to take in violation of a BGE directive, or do you move the guests to the embassy suites across the street?
Well, we would do every effort would be made to relocate the guests to any available hotel at the cost. The hotel would absorb the cost of that.
But that did not occur in January?
No, it did not, because of us, because of the situations that had occurred and us going back onto the gas grid. We did not need to relocate any of the guests because our boilers were working and providing the heat needed.
Placing the distribution system at risk, because the hotel was taking unauthorized takes from the pipeline system when it knew it should not have.
At that time, yes, because of the circumstances that had occurred.
Okay, thank you. Commissioners, Commissioner Richard.
Yeah, I just wanted one question. So on October 10th, 2018, is it true at that point you were aware that two of your boilers were not functioning? Am I reading the information correctly?
Yes, Your Honor. And
so at that point, you had lost your redundancy. Was there any discussion at that point whether or not you were right to be a limited service customer, interruptible service customer?
it's my understanding, Your Honor, at the time there was not an expectation that it would take as long as it did to get some of the parts manufactured and replaced. So I do not believe so. I'll defer to- I'm told no, Your Honor.
Okay, so there's no discussion at that point. But that was because you believed you were going to be able to have the redundancy necessary in a couple months' time when you're in winter.
Yeah, Your Honor, they didn't expect it to take 3 to 4 months, and then when the parts were installed, it takes time to get on the Department of Labor and Licensing and Regulation boiler inspection list, wait list, I guess you would call it.
And leading
schedule.
So as you got into the January timeframe and you still did not have those parts, again, was there any concern or discussion about, gee, maybe we should not be an interruptible service customer, or any reaching out to BG and explaining your situation?
I'm told no, Your Honor, but again, they did contact BGE on January 18th to say 2 of our boilers are down.
Right.
Ms. Main has confirmed that with BGE.
But that was late in the month.
It was later in the month, yes, Your Honor.
Okay. Okay, well, thank you.
Thank you, Your Honor.
Commissioner Linton.
Thank you, Mr. Chairman. I'm interested in finding out how you first obtained the utility account back in August 3rd. Did you just assume the old account? Did you get a brand new account number? Did you just assume the old account and pay on it as the last owner of the property did?
Yeah, during takeovers like that, it's generally the accounts are just assumed.
So you just assumed the account. So there wasn't a brand new, fresh start
No,
for your customer.
It was not.
Okay. When you took over the account and had to change the contact information, pay information, etc., was there any communication between you and the utility regarding the responsibilities for IS, interruptible service, and making sure that there was the appropriate inspection? The utilities do that once a year. According to the filing from the staff, it looks as though it was just a paper certification that you were prepared. Was there any other kind of review by your company or by BGE before the winter period?
I cannot answer that because I was not involved directly with that at that time.
Your Honor, when they took over the property, again, it was through foreclosure proceedings, so it was not your friendly type of acquisition. They took over the property. They began doing, if Your Honor has seen the records, a series of inspections of the equipment on site. They started performing their due diligence to figure out where are we in the property. Having actually been to that property a number of times, we were talking before, over the years I had noticed a degradation in the facility itself. A client of mine even talked about it when we met there. So when they took over, the first step they had was kind of figuring out where are we with regard to the property, what does it need. So they had both DLLR, Maryland DLLR, do boiler inspections on 2 of the boilers. The boilers are staggered inspection. Every 2 years you get inspected. So 2 of the boilers have been inspected in 2017. 2 were inspected in 2018. That's where these issues came up. Likewise, our insurer, AIG, had done some inspections. There's some inspection reports. You'll also notice in the attachments that all the items on those inspection reports under our exhibit 1-6 dated May 3rd, 2019, note that all the items that have been listed for the most part either had been, as a follow-up, had been completed and the items were closed out. So all those items had been addressed too. But unfortunately, at the time when you're dealing, I assume Your Honor is familiar with the property. It's an 18-acre, rather spread out hotel. It's quite a bit just to sort of figure out where you're at the time. You've taken over a property that had not been properly maintained, and trying to figure out and prioritize the things. And then boilers were a priority. Like I said, unfortunately, we had to wait longer to get some of those parts because they had to be custom manufactured.
So when you assumed the property in August 3rd of 2018, did you receive the new account number? You did not?
No, there was no new account number at the time.
You placed your company name onto the account and removed the other company?
There was a name change done on the account, which is not uncommon.
Right. Okay. Thank you.
Thank you, Your Honor.
Commissioner Herman.
Okay, so I've heard you say that the company DOF4, Hunt Valley, knew that the property had not been properly maintained prior to its takeover. Is that right?
No, Your Honor, they were lenders, so until they actually got possession of the property and could take over, they're a lender. It's no different. My bank doesn't come to my house and inspect to see how it is. Once the foreclosure proceedings happened, somewhere in that short time frame, and then they took over, got access to the property.
Who's they?
DOF.
DOF.
Porchlight, yes.
Right, and that's who we're talking about now, who's subject to the fine,
Yes,
right? Okay. But you took it over, DOF took it over, and very quickly acknowledged in spring, presumably, that it wasn't properly maintained. Is that right?
No, Your Honor. The foreclosure took place in August. I think we got formal possession late August, August 3rd. And once that happened, we started performing due diligence on the property. We brought in AIG in September, October, basically end of the third, beginning of the fourth quarter of last year.
Okay.
And that was where the various inspections took place. Under Exhibit 1-2D, you can see that there were boiler inspections that took place by DLLR of boilers 1 and 4 on 10/10/18, and it was in that time frame that the inspector said, "Hey, you've got some issues with this equipment." We're not boiler engineers, so when they came in and said you have to make these repairs, that's really what got the ball rolling with trying to effectuate them.
Right. Would you say that DOF 4 Hunt Valley Master Tenant LLC is a sophisticated entity?
They're a sophisticated lender, Your Honor. I mean, they've outsourced management of the property, management of the hotel. It's a franchise. It's a Marriott branding, but Crescent operates the property, and they were brought in again after the foreclosure.
Right.
But
And after the foreclosure, you knew that you were on interruptible service. Is that right?
Yeah.
Right. And you knew that interruptible service has conditions. Is that right?
We did, Your Honor. Yes.
Right. And did you seek prior to the winter season, when you knew that there were significant consequences to failure to interrupt? Did you seek prior to the winter season to review your status and understand whether you could or you couldn't interrupt?
So, Your Honor, I think the answer to that is we thought we had the status to do it. We had 2 boilers that were down. We had 2 boilers that were operating on oil. The only time that we would switch over to gas is upon notification gas to oil would be during an interruption. And it just happened that when we were directed to do it, we tried to do it. It's not like we avoided it. We didn't try to do it or anything.
No, I
like
understand that. I understand that. In fact, you sent a letter saying that, or there was a piece of paper that said that you were prepared to interrupt. Is that right?
Yes, and only when we went to switch over during the interruption period, and as staff has recognized, the air compressor on one and the oil pump on the other failed. I can't tell you, would that have been discoverable 2 or 3 months earlier? I honestly don't know. From my perspective, if I get in my car and my battery's dead, obviously, if I know the battery's slowly going to die, that's one thing. But if I turn on the car and it's click, 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 I can't plan that ahead. I don't think
I think that, I think it's a different analogy. I'm not sure that analogy works. Because here, you sent in a piece of paper saying you would be able to interrupt, and maybe you didn't have the sufficient facts to know that, and perhaps you shouldn't have sent that piece of paper. That's a different question. But and then you've been talking about how old these boilers are, and that you can't get parts, and all of that. So this was known in October that these were old boilers, and that you couldn't get parts, and that it took a long time to get repairs, and yet you still had the benefit of the interruptible service without really being able to certify that you would be able to interrupt. Isn't that right?
It is, in the sense that, yes, we owned the building at the time, but we had not operated the building for but a couple months at the time. We were still trying to figure out, with regard to mechanical, electrical, telephone, waterproofing, windows, roofing, everything that was wrong with the building, and trying to prioritize that and work through that. This is not an instance where we, for years, my client, allowed the property to go into degradation. It's the opposite. We tried to find out what the problems were, when we could get access to the property, when we owned the property, and try to fix them as rapidly as possible. Unfortunately, as I started off my opening with, it was sort of a perfect storm. Bad weather. We tried to switch over in good faith. I think we've shown good faith efforts here. And a couple pieces of equipment broke or died that we couldn't anticipate. We didn't know. Had we done that before, I can't say what would have happened. It didn't happen, though, and it's not like it was an intentional thing. I do think we've met the standard of good faith under the regulation in this case, respectfully.
Okay, thank you.
Commissioner O'Donnell.
Thank you, Mr. Chairman. So the staff's buck sheet lays out that 2 of your boilers were out of service while awaiting final inspection to ensure their mechanical integrity, including the ability to comply with service interruption. and when the call came, the other two boilers failed. Do I kind of have that correct?
So the two boilers were waiting to come back online, yes. The other two boilers were working under natural gas. It's when we got the call, our engineer tried to switch over. The air compressor on one of the stopped working. After it started working, by the way, on oil.
Right.
The other one, he turned it on, and the oil pump wasn't working.
Right, but boilers 1 and 4 were still out of service, and then the two that you hoped would work didn't work.
That's correct. Under natural gas, yes, Your Honor.
And when did boilers 1 and 4 become operational again? When were they available to you?
Number one should be operational this week. We have technicians right now starting to fire it up. Number 4 is ready to go.
So, back in, way back in the beginning of the year, in January, when this event occurred, boiler 1 was out, and it's still out?
1 and 4 were out, and we fixed 4 right now. That's why we say number 4 is ready to go. Yeah,
Here's what I'm trying to ascertain. For you to be prepared to assume your interruption status, you got to have all 4 boilers. Or if you don't, you got to know you're in a vulnerable position, right? You understand? Right?
Your Honor, part of the problem was it's one thing to have the boilers up and running. You got to get them inspected before you can turn on the switch.
I get
That was part of the problem, was getting on DLR's schedule. I can tell you, I've told my client, get on DLR schedule to the extent you need it for the boilers. But I am told that these things are all 4 will be up and operational for the year. And again, it's a good faith effort. It wasn't intentional that this happened.
Yeah, I'm not suggesting it is. So I'm going to tell an anecdote here, Mr. Chairman, that the kind of chance that I'll delay things inordinately. But when I was a young kid, maybe in the mid-70s, 74, 75, I actually was given a summer job to climb into boilers and scrape them out with a wire brush. I had a good dust mask on, though. Not sure how effective it was for me sucking in that particulate. But the school district got good cheap labor in the form of a kid climbing down the burn box of a boiler, and I also got to stick a long wire brush on the end of a motor down the heat exchanger tubes to clean them out and make sure they were efficient as well. So I don't know, at that time I'm a kid, I don't know anything about that, but I do know this from that lesson. I do know that when we did those boilers in those public schools, that they had to be ready by the end of summer. And any deficiencies that were identified had to be able to be fixed prior to the winter heating season, or the kids wouldn't be able to go to school. It seems like a very basic premise. The same applies here. And you're very sophisticated people. You're financiers, you're bankers, you run hotels, you're in the hospitality industry, and you know your obligations. When you put your name on that account, you know your obligations are to take the obligations of the previous holder that you took this property back from, and you assume all of the liability for them, including the liability to interrupt service or pay a consequence for it. And now here we are. You weren't prepared. You couldn't interrupt service. And you weren't able to heat the schools, so the kids couldn't go to school that day. It's as simple as that for me. I don't, everything else is kind of window dressing.
But Your Honor, again, the standard is, did we make a good faith showing? And I think that we have made a good faith showing that we did what we could. The fact
But your boilers are still out of service from back in January.
Well, we have hot water. We don't need heat for the building right now. So the boilers for heat purposes, and you've heard, will be up and operational in plenty of time for inspection and for the 2019-2020 heating season.
Let me ask you this. When you took over the property and you knew that you had maintenance problems, you started discovering that the property was in disrepair and not well kept, when you changed the name on the account with BG&E, did you explore the opportunity to go to a different schedule? Or did you roll the dice?
It was not discussed at that time that there was a need to do that.
Maybe do you think you should have? Was that an option to you?
I'm sure it was an option to us, but as the property director of finance, something like that is actually quote unquote above my pay grade, which would be discussed at more of a corporate level or an ownership level to decide to do that or not.
Your Honor, whether it didn't happen or did happen, it is happening now, is all I can tell you. And again, there's no intent here.
Well, you keep saying that.
I know
no one's
that, but
implying that.
I know that. For drinking from the proverbial fire hose here, trying to figure out what happened, and again, to get a penalty of $340,000, under these circumstances, I think that these are different than what you might normally see, where someone has owned the property for multiple years, has maintained the property poorly. We got in, we did what we could as quick as we could. The fact that we couldn't get some parts, and then, frankly, get an inspection as quickly as we could, unfortunately, it's just, again, it was a perfect storm in this case.
Thank you.
Thank you.
This obviously was a unfortunate instance. Machinery breaks, deteriorates. I recognize that you were the new property owner. This was the first winter. However, I do not find that your clients exercised good faith. There's no evidence on the record that any attempt was made to curtail usage on January 30th, and we have no record or evidence from Mr. Tessar or anybody that BGE was contacted in the interim, which would have allowed BG&E to reconfigure its system in the event that it was going to put additional strain or violate any limits on the system. It could have adversely affected the integrity of service to other customers, and for that reason alone, I don't find that the company has met the good faith standard. Commissioner Richard.
I believe the company did meet the good faith standard. They inherited a distressed property, and they worked hard in a short period of time to get it, I guess, so we could accommodate guests. And also, they inherited an existing account. I don't know if at that late date they would have, thought to even consider what the gas service, account looked like, and again how it seemed to work for the previous owners. And so I don't, again, because of the late date, they would have, even looked into it. From my hearing, they did attempt to switch service, and that's when the failure took place.
Yes.
And at this point, they are operating a hotel that are accommodating guests. You certainly don't want in a cold snap to freeze out your guests or to suddenly displace them. And the fact that they are now looking at their situation and considering firm service, I believe, are all the elements that I need to see to assume good faith. Can I ask, have you already paid any part of the fine? You said you were getting $30,000 in addition to...
Yes, Your Honor. We've paid, as I understand it, the first component posted in May, so May, June, July, and I believe August.
But yeah, May, June, and July have been paid. August was just received, so that is in process to be paid.
Okay, so it's 30, 60, 90. You've already paid a...
Yeah.
Are you trying to get any of that back? Are you...
Your Honor, in talking with BG&E, they said that if we switch schedules, they'd be willing to consider not going forward, but they can't go backward without the Commission's permission to refund those prior payments. So that would have been an alternative remedy we would have requested. If the
Right. Well, I guess my position is that I support the good faith effort, but I think fine paid is sufficient at this point.
Commissioner Linton.
Thank you, Mr. Chairman. I actually agree with Commissioner Richard. I think that a good faith effort was made here to curtail the company. When they first obtained this property, I actually think that they should not have been on the interruptible service tariff in the first place. This was a distressed property. It was in foreclosure. These were old equipment that was being relied on for purposes of the interruption. And so that should have been determined prior to, if not by inspection by the prior owner, certainly by the review that the company would have used in keeping them on the tariff, so that you didn't have a situation like this come up, because I believe it would have happened regardless of who owned the property at the time. So this was a decaying situation for several years. And so perhaps the prior owner was benefiting from the interruptible service, and maybe they were able to interrupt them, or maybe they were never called to do so. But at the time that this new customer came on board in August of that year, that gave them about 2.5 to 3 months to get ready for the winter season, and that's a lot to do when you've secured the property through foreclosure. So I personally think that even after all of that, and the effort to switch over, to find equipment not working when they've switched over, and with all of the other work that was going in to try and take care of this property at the time, they shouldn't have been on interruptible service, but to the extent they were, I think that the effort was made. And I would agree with Commissioner Richard that the amount paid thus far is more than sufficient, and since it was already exposed, the total amount of the fine is significant.
Commissioner Herman.
Thank you, Mr. Chairman. I'll admit I'm torn. I think this is a sophisticated entity that, even though in foreclosure, would have or should have knowledge of the fact that it was on an interruptible schedule, and if it was unsure as to the condition of its equipment, should have taken actions to remove itself from the interruptible schedule, and had adequate time between August and January to do so. But on the other hand, I see that they also have they also have taken a number of actions, which I agree with, and the fine is significant. But I think on the whole, this is a large, this customer uses a decent amount of gas here, and in fact, BGE relies on its interruptible service customers to interrupt. And while I understand that the new owners, or the taking over the property, that you had a lot of issues to take on, we have to consider the fact that there could have been issues in the gas system because you are a large user, and that does cause me some concerns. And I think that these penalties are there so that these kind of problems don't happen, and that people do everything that they can to interrupt. So I think I will stand with the chairman and say that while I don't think it was deliberate, I don't think we've had sufficient good cause.
Commissioner O'Donnell.
Thank you, Mr. Chairman. The chairman may have thought that I had already made my vote clear. Maybe I have, but I want to say this. Climbing down the burn tube of an institutional boiler may not qualify you to make a legal determination here, but I can say that I am qualified to make a determination that those boilers should have been ready and they weren't. That may not be the fault of the current owners. I'm not suggesting that it is, but the obligations of the tariff and the obligations of the schedule that you on clearly were, and you're legally obliged to be held to those. And so for that reason, and for the reason that Commissioner Linton stated, but only in the obverse, you should have been on a different tariff, and you had the obligation to change that tariff if you thought there was a risk that you wouldn't meet your obligations. And you didn't do that. You didn't change that schedule. That allows you as a customer to get a reduced rate compared to all the other gas customers in the system. With the cost being, the caveat being, that when you're called upon to interrupt to save the system, you will do that. You didn't do it, you didn't meet your legal obligations, and therefore I find that the recommendation is just, and that we should uphold the recommendation of the staff.
By a vote of 3-2, the request for waiver of DOF for Hunt Valley Master Tenant LLC is hereby denied. Madam Secretary.
Your Honor, can we request to have the fine that's been paid today act as the fine thus and waiver going forward?
No.
Thank you.
Thank you. Madam Secretary.
Item 14 is Forefront Power LLC et al. Filed on August 13, 2019, a request for a waiver and extension of the operational deadline for community solar energy generating systems pursuant to Comar 2062-0304C.
Mr. Chairman, Commissioners, Annette Garofalo again, on behalf of Commission staff. Forefront Power LLC is seeking a waiver of the operational deadline established under Comar 20-620304C for 2 community solar energy generating stations, both of which were accepted into PEPCO's interconnection queue on August 7, 2017. The basis of this request is that the Prince George's County Department of Permitting, Investigations, and Enforcement did not issue the building permits necessary for construction of the projects until August 9, 2019. This is Forefront's third request for an extension of the operational deadlines associated with these projects. The current deadline, as extended by the most recent applicable commission waiver, is September 1, 2019. Forefront's attempts to obtain county zoning approval and permitting for these projects, for which it is seeking a waiver, was implicated in each of its earlier waiver requests. At this time, construction is underway on both projects, and both projects are fully subscribed. However, neither the Chrome Road nor the Osborne Road community solar stations has been completed. Forefront has shown itself to be serious in the choices required to complete the CGISs for which it has obtained capacity. Forefront has withdrawn 2 projects from year 1, one which is expected to go online as a year 2 project in August 2019, and another which was canceled due to a change in interconnection requirements. In addition, Forefront has placed 1 additional year 1 project into operation. Given that with the issuance of the building permits, there appears that there will be no need for any additional waiver for these 2 projects, staff recommends an extension of applicants' operational deadlines for the projects to October 18, 2019, as requested.
Thank you. Does counsel for Forefront have anything to add?
Yeah, good morning again, Chairman and Commissioners. Eric Wallace with Green Herlocker here for Forefront Power. I'm joined by Brian Malashevsky, who's the project manager for Forefront's Maryland projects and has been working with Forefront since they entered the Maryland market. These projects were purchased partway through development last summer, so he's been working directly on these projects since Forefront took over. And Brian Eckstein is also here from Forefront Power. He's a vice president for the company. And, you know, as we've indicated in our filing, you know, we come before the commission here once again very reluctantly, understanding, you know, the commission's frustration with the delays in developing these projects. We think that the filing that we presented shows good cause for an extension based on the diligent efforts of the companies to bring these projects across the finish line. You know, the extension we requested for here for both these projects is until October 18th, and we've been working with the utilities and the counties and all of the involved parties to make sure that, you know, that at this point, with the permits in hand, we're able to meet that deadline. Previously, in our previous extension requests, we came before we had, you know, well, due to zoning delays and permitting delays, but before we had permits in hand. As we've demonstrated with the Philadelphia Road project in the Baltimore Gas and Electric Service territory, once the permit is in hand, then Forefront has a lot more control over the timing because they control the construction schedule with their contractors, and as demonstrated with that project, they were able to meet the extension request of the end of July. And then also, as staff noted in their comments, they have 2 projects that were originally in year 1 that won't be able to finish in the year 1 cycle. That they are not pursuing further extension requests for, and in one case to a significant loss to the company. But understanding that, you know, every time we come before you, it takes staff's resources and the commission's time to consider these matters. But for these 2 projects, the company has been committed throughout the process. They're fully subscribed and ready to go, and you know, we just ask for this last opportunity to finish these projects and deliver their value to the Maryland residential customers that have subscribed and are awaiting operation.
Thank you, Mr. Wallace. Do the commissioners have any questions? Seeing none, is there a motion?
Someone else is going to have to make this motion and make that statement when I vote.
Yes, Mr. Chairman. I move we grant the company a time-limited waiver time-limited waiver of Comar 2062-0304C, extending the applicant's operational deadline to October 18th, 2019 for its Osborne Road and Croom Road projects.
All in favor?
Aye.
Any opposed?
Opposed, and I'd like to explain my vote, Mr. Chairman. I laid it out for solar projects earlier on a different set of projects, but I got to tell you, this is the third time this project's been extended, and so I'm going to vote no because I believe it's wasteful of the staff of the state and the resources of the state to continue to grant an extension or a waiver, if you will, to the rules, and the rules aren't followed on a regular basis on these matters, and I'm not going to continue to oblige it. I'm just not. I think it's wrong, and I think we ought to get these projects done with our original commitments. Commitments should mean something, and they don't seem to on these projects.
By a vote of 4-1, the motion is approved. We'll take a recess now for approximately 10 minutes, reconvening at 12:35 p.m. We are back on the record. Madam Secretary, the next item, please.
The next item is item 15, Power 52 Foundation, filed on April 24, 2019, a request for an official opinion around co-location of community solar systems.
Thank you, Mr. Albert. I'm thoroughly confused by this application, so if you could walk me through it, I would appreciate it.
Sure, Mr. Chairman. This has taken us many twists and turns. I would note Mr. Robert Wallace from the project is here, and he is the co-founder and CEO of Power 52, and he's been very helpful walking me through this.
Thank you. Which one is Mr. Wallace?
That's me on the
Okay.
Yep,
At
sorry.
the end. This item addresses a filing by Power 52 Foundation that asks the Commission determine that the two solar projects proposed by an entity named Mead Communities LLC satisfy the requirements for a community solar facility. Power 52's filing is in response to the decision by Baltimore Gas and Electric, BGE, to reject Mead's request for an allocation of community solar capacity as part of the Community Solar Pilot Program. Power 52 states that if the Commission determines that the Mead projects violate the Public Utility Article, or COMAR, regarding community solar, the Commission should waive the applicable standard. And Mead supports Power 52's filing. Mead's two projects would be located on the same land parcel as the two Power 52 projects on Frederick Road and Broadwater Lane in Howard County, Maryland. When Mead asked BG&E for allocation of community solar capacity for the two Mead projects, BG rejected the request because each of the projects is co-located with one of the two projects that have been approved for Power 52. BG explained to staff that BG relies on the real property parcel information maintained by the Maryland Department of Assessments and Taxation, we refer to as SDAT, to determine if multiple projects are co-located on the Commission standards. COMAR 20.62.03.08A4 states that, quote, one or more subscriber organizations may not construct multiple facilities on a single parcel of property. Staff believes that the SDAT land parcel information is the appropriate basis for determining if there is co-location. Significant here is that Mead seeks to co-locate with the two other projects by Power 52, which means that there would be more than one subscriber organization on a single parcel. Thus, the Mead projects would violate the fourth standard in the co-location regulation because there are multiple subscriber organizations and facilities on a single parcel. Now, the Commission did create several narrow exemptions from the co-location restrictions, but none of those exemptions is applicable here. Hence, the project does violate the fourth standard in the co-location regulation, and therefore would not qualify under the regulations. Now, Power 52, as apparently acknowledging that, has asked for a waiver of the regulation. Generally, a waiver of a COMAR requirement can be justified if there's good cause, and a key factor in determining if there's good cause is whether the waiver would be consistent with the goal of the law under which the regulation was adopted. Power 52 told staff that the proposed co-location of the Mead projects with the Power 52 projects would reduce costs that Power 52 and Mead would incur to connect with BG's distribution grid. Power 52 said these savings are necessary for Power 52 to provide cost savings for its low and moderate income customers, LMI customers, which is a designated category under the Community Solar Program. True, co-location of community solars would typically spread across the multiple facilities at a single location the cost of constructing the interconnection with the local utility, which is typically going to be a major cost. However, if minimizing costs was the only objective, the Commission would not have adopted regulations that impose restrictions on co-location. Also, the community solar law itself states that, quote, equipment for a community solar energy generating system may not be built on contiguous parcels of land unless the equipment is installed on building rooftops. Again, if the General Assembly was only concerned about minimizing costs in connection with community solar, the General Assembly would have not imposed this restriction on community solar projects on contiguous parcels. Also, if cost savings alone justify a waiver, our concern is that virtually all projects would be able to qualify for the waiver because, again, any project would benefit the community solar projects would benefit by splitting the cost among multiple projects on the same parcel. Now, essentially, this would mean the exception would swallow the rule. That is the rule here against co-location of multiple projects. And we believe this would be clearly contrary to the intent of the General Assembly and this Commission in imposing restrictions on co-location. We would also note that there are important policy goals that are served by these co-location restrictions. First, community solar is a limited-term 3-year pilot program. Therefore, we believe it's prudent to restrict the size of the project, of a community solar project and co-locating, in view of the fact that the Commission may choose not to adopt a permanent program. Second, the restrictions on the Public Utilities Article and the Commission's regs on co-location and the size of a community solar project encourage the development of a large number of small community solar projects that are located throughout the state. This ensures that customers throughout Maryland can receive the benefits of community solar. Put the other way, absent the co-location restrictions in COMAR and the Public Utilities Article, there is a risk that there would be a small number of very large community solar projects that are concentrated in only limited areas of Maryland. Thus, we believe that waiver of the co-location restrictions for the 2 MEAT projects would be inconsistent with the objective of the community solar co-location restrictions in COMAR and the Public Utilities Article. On August 5th, OPC filed comments that state that they agree with staff's position that the MEAD projects violate the COMAR co-location standard and that this standard should not be waived. Staff's comments go on to say that to ask the Commission to determine that no more than 2 megawatts of generation on each of the 2 land parcels used by MEAD are eligible for net metering. However, Power 52 told staff that Power 52, quote, will not be net metering these projects. The projects will be approved under community solar, and I confirmed earlier today with Mr. Wallace of Power 52 that if the Commission determines that the MEAD projects are ineligible for community solar, the projects are not seeking to do net metering. So that portion, the staff is not asking for a ruling on that issue because it essentially is moot. That is the issue of net metering. Overall, given the fact that we do have a violation of the co-location restriction and public policy objectives of a waiver would undermine the purpose of those restrictions, staff recommends that the Commission, 1, determine that MEAD's 2 solar projects violate the co-location restrictions in COMAR, and 2, deny Power 52's request for a waiver of these restrictions.
Thank you, Mr. Albert. Very cogent and clear recitation of staff's position. Thank you. You mentioned OPC's position. We have that on the record. Anything to add from OPC? Mr. Sheehan? No, Mr. Chairman. Okay, thank you. Counsel for Baltimore Gas Electric.
Good afternoon, Mr. Chairman, Commissioners. Daniel Herson for Baltimore Gas and Electric. I'm joined by Mr. Steve Bartenfelder, who's BGE's Community Solar Program Administrator. I'll try to keep our remarks pretty brief. Mr. Bartenfelder, when he's administering this program, and myself, when he brings certain issues to my attention, both of us try to make decisions in this program based on what we can hopefully do is a clear and concise reading of the applicable COMAR requirements. If I can look at COMAR, say, hey, that's pretty clear, I'm going to rely on that to make my decision and then advise and counsel Mr. Bartenfelder. And that's what we did in this particular situation when we were faced with the facts of having 2 separate parcels of property, but having 2 different sets of companies applying for projects on both of those 2 parcels. And so luckily COMAR does have a provision for this very situation, which is 2062-0308, which is the project location section of the community solar regs. And so we took a look at that. And under the co-location section, Section 1 says an electric company may not accept a CSEGS project, 500 kilowatts or greater, that is proposed to be located on the same or adjacent property as an existing or proposed CSEGS project owned by the same subscriber organization or affiliate of 500 kW or greater in its service territory. So you read that and you say, okay, that's pretty clear. And maybe you can imply from that provision that BGE or any utility running one of these programs could accept applications from non-affiliated companies, which I believe is Mr. Wallace's position. But then you get down to subsection 4, which says one or more subscriber organizations may not construct multiple facilities on a single parcel of property. So there you're looking at a direct prohibition, as I read it. So when Mr. Bartenfelder and I sat down to try to decide what we're going to do here, we acknowledged that there might be some tension between those two provisions, but we thought that subparagraph 4 was the more direct and clear directive to us in terms of how we were supposed to handle these situations. So that's what we did. We went with subparagraph 4 and denied Mead applications for both the Frederick Road property and the Broadwater Lane property. We actually did approve Power 52 for both of those properties because they had submitted their information prior to Mead. So Mead was just second in line, so under our interpretation, we went with Power 52 and granted them approval. I would say that, on this particular waiver request, we're not taking a position for or against it. I agree with Mr. Wallace that I think some interpretation here, or some guidance from the commission could be helpful because I think we're probably going to see this situation come up again. I'm just telling the commission that this is how we went about making our decision on the facts that were presented to us, and for the reasons I gave, and really also for some of the policy reasons that Mr. Albert mentioned that the state had behind this program, we decided to deny Mead their applications, but we would certainly agree with Mr. Wallace that some guidance could be helpful here.
Thank you, Mr. Herson. So the application for Mead has been denied. Is there counsel for Mead present today?
No, they couldn't make it. They had the issues up yesterday, so they couldn't come down. Yeah.
Okay, that's unfortunate.
But they submitted a letter of support though for the project.
Previously, right?
Previously,
that was,
yes.
yes, yeah. We received that. Mr. Wallace, would you like to make an introduction?
Sure. So what I always like to do is kind of run our video first real quick because it just highlights exactly what we do as a company and what our mission is. And I think it's important to understand that as we look at and discuss this conversation around co-location. And I apologize if it's too long, but we did the best we could. We affect people, we affect the country, we affect the planet. That's the benefit of Power 52. On average, the solar industry has grown 34% per year over the last 7 years, right? And you see the potential which it has in terms of being the #1 fuel source for this country.
A lot of people want to make money, I get it. But what we're trying to do is funnel money to go directly into people.
And that was the goal of Power 52, right? To take the access and the people, the resources that we have, and not necessarily keep them for ourselves, but impact the community we serve. Look at what's happened in the world with these natural disasters. Resiliency and infrastructure. How do you prepare for disasters so to make sure you have stable and renewable power, dependable power, even after a storm, right? Now you're talking about battery storage. And that's the kind of infrastructure this country needs and the world needs. Grid on demand. God system, right? You have a renewable source that as soon as you deploy this system and the sun comes up, you have electricity. You're not waiting on embargoes for oil tankers to come in. You're not waiting on people to bring additional resources. You have power from the sun that's stored and harnessed by battery storage that can immediately be used within hours to bring a country or a city or a village back up. That's the advantage of renewable energy.
Yeah, you just think about something that Richard Branson did with Necker Island in 2017 to see how quickly the transition is made to get back on his feet. Lots still to do, but to get back on their feet that fast is what the solution is and what we create.
And I would go back to the orphanage, Dominican Republic. Right? We went in and put in a solar generation system with battery storage and a generator. 2 weeks before the hurricane hit. The hurricane hit, and they called us because they were the only place in the village that had electricity. 61 little girls had electricity, which meant security during a time where the world was running rampant around them in the Dominican Republic. That's the advantage of grid-on-demand systems. That's the advantage of renewable energy systems and battery storage.
My name is Dion. I basically got out of prison last year. I got locked up at 16 years old for a high-profile case. And when I came home, I put it in my head like I wanted a family because I thought like maybe one day I might not even come home. But I ended up going to workforce development, and they told me about Power 52. They help you with suits, they help you with job education, workforce development, all these type of things that put you in a different mind state or put you in a different elevation so you can better yourself. Being from where I'm from, a lot of people don't make it towards higher elevation just off hood, you know what I'm saying? You end up dead or you end up locked up. For me to be able to have a mentor that's positive, that went through positive transformations to become financially good, and it's just a blessing to be able to talk to him every day and ask questions of how to get here or how to get there.
With a career path like moving into solar, man, your options are unlimited. And whether you're a veteran, you've served, whether you've had, some hiccups in your past, it does not matter. We can get you moving in the right direction as far as a solid career in your future.
Being a woman, I have a college background, all that stuff. I just couldn't land a job that paid decent enough money to take care of my family. So a friend of mine told me about Power 52, gave me a flyer, and I took advantage of it. I pushed myself, and I actually was one of the top in the class. And we're all family. So with Power 52 helping in the community actually grow and do positive things for kids, and it's just awesome. It's a totally different world with Power 52.
There's a future in clean energy that we're preparing these young people for. Right. And by giving them this skill, this is something that they can take on for generations.
So this is where we do our labs and our hands-on training. We call it Solar Boot Camp, where the guys and girls come out here for a week, out of the cities, out of wherever they're from. They come out here and they participate in doing full construction of a system. When they see the green light come on, showing that the system works, you should see their face light up. Like the first time they plug it up, we pull it out into the sun so the sun hits it, and the thing comes on, the batteries kick on, and we plug up something and it's powering it. Man, everyone's high-fiving. It's a great experience. And so once they've done this solar boot camp piece, the next piece is actually take them out to the farm where we build stuff like this, where you're putting in 30,000 solar panels. This is just a microcosm of the larger systems, and that's why it's so important for them to have this hands-on experience. So this system here was built by Power 52 Energy Solutions guys. They came through the training program. They were hired by us as part of our training initiative, and they're the ones who actually assembled this whole project, from the racking to the module placement to the DC wiring to the inverters. Everything was done by Power 52 Energy Solutions and the graduates from the training program.
Once Power 52 is brought on board, we will establish training facilities. Power 52 will then bring in technicians to train locals in an 11-week course in which they will receive the necessary certifications to assemble solar systems. With that knowledge, locals will then have the opportunity to build solar using the solar equipment provided by Power 52. This cycle of creation of new job opportunities will not only increase the economic sustainability, but will allow the people to take pride in their own work to fight climate change personally and set an example for the rest of the world.
Creating the jobs, right? We're creating opportunity. We're saving people money, right? And we're changing the earth. We're protecting the earth from the pollution, everything we've done so far to tear it up. And that's the benefit of Power 52.
Cool. So sorry it was so long, but it kind of like highlights a lot of things that we've done as a company and what our mission is. One of the other things it does for me is just reinforce why we come forth with these kind of battles and these struggles, especially around the communities we serve. So we started Power 52 in 2015. Myself, Ray Lewis, and Cherie Brooks. I'm a graduate from Polytech here in Baltimore City. Went to Virginia Tech for undergrad electrical engineering, back here to Hopkins for electrical engineering. Worked in Northrop for a while and got into renewable energy in 2007. So I built over 100 megawatts of projects here in the state, about 200 or so nationally, a lot University of Maryland, Coppin State, you name it. We built those projects. But in 2015, we had the riots in Baltimore, and we were sitting back and we were watching, I'm going to say, kids tear up their own communities and own neighborhoods. And what came through to us was this is a systematic issue of where kids have lost hope. They lost the opportunity to see how they can get outside of the hoods within Baltimore. And so what we decided to do was create a vehicle that we could educate and train returning citizens, veterans, and guys and girls who might not necessarily be college material, but they have a career they can launch and participate in the renewable energy sector. And so we started Power 52 Energy Institute in 2015 with one location. We currently have 4 locations. We're opening a 5th in Baltimore County now. We've trained over 200 or so individuals, 85% placement rate. So even the guys and girls who have come out of the prison system are placed on full-time jobs mostly in renewable energy and solar construction and development. So part one of our mission was how do we train the individuals locally so they can benefit from this renewable energy revolution, hence why we focus so hard in Annapolis for the Clean Jobs Act, to make sure that these jobs stay local. By incentivizing businesses to produce and build here, it creates jobs for our guys and girls, and then that system creates opportunity for them here in the state. The second piece is providing access to renewable energy, right? If you look at most of the individuals served by solar development, it's not low to moderate income. It's not folks who may not own their facility, may not own their roof, may not have the credit or the cash to be able to benefit from solar power. And so the purpose behind community solar was set up so that these folks who didn't have these rooftops were able to also benefit, not only from the jobs, but also from the savings that comes from it. And so what's happened though is you have all these developers. I'm taking my developer hat off, which I took off in 15, and put my impact investment hat on and said, how can we help people? The deals don't pencil unless you have these subsidies in place to help, right? So what happens is, if you look at the pilot program and you look at the capacity allocated for low to moderate income, there's two programs. One is around the other program, which is mostly 51% higher LMI, and then there's the LMI piece. 90% of those applications are Power 52. Why? Because no one else wants that market. It's hard to finance, cost of capital is high. There's a perception that the fallout is high, that people aren't going to pay their bills. But for us, this is how we show that LMI people can participate in community solar programs. Because the goal, I believe, of the industry is to prove the pilot's a failure, to prove that LMI people can't participate. We need to remove that capacity and give it to everyone else. So all my friends say I'm crazy because the money is really in the good credit. The money is really in the retail side of community solar. And so when we look at how to get that cost down, right now we offer 25% savings to LMI. No one else is doing that because you can't. You can't make the deals work unless you substantially cut your commission, find a cheap cost of capital for high risk offtake, right? Or find some way that you can finance the systems yourself. They can't take the tax credit, right? They can't finance on their own. And so it's programs like this is the only way they can do that. And so what we do at Power 52 is look at strategically how do we develop these systems so that we can decrease the cost, we call the EPC cost, or the cost to construct, to a number that even with a 6 or 7% return investment threshold for an investor, we can still offer 25% savings to low to moderate income. 10% savings is not going to get them to transact. It's not enough. Between the 10% and then having to prove your LMI, which is crazy to me, to prove that you make under $30,000, I could see if we had a special subsidy for LMI projects where you qualify for this and it buys down the cost, but to prove just so we can check a box to say we serve poor people, that doesn't make sense. So to have to do
Mr.
that,
Wallace, if I could
Yeah.
interrupt, this is an issue that the commission is aware of with respect to difficulties enrolling LMI customers. It's going to be pending in other dockets, so we'll be tackling that issue. If I could direct you to the legal matter at hand, you heard Mr. Albert's position, you heard Mr. Herson's position, and we do appreciate learning some of the background and the mission and good work of Power 52.
Sure.
So how do you respond to Mr. Albert?
couple things. Number one, for us, what's important to understand, it's a pilot, right? The purpose of the pilot is to test, does this make sense with the current policy, the way it's set, and do we need to make changes to make sure that the program is successful after the pilot period? So I understand that it was written where you cannot co-locate, you shouldn't co-locate multiple solar farms. However, what we're saying is if that project is aimed to serve low to moderate income, we're asking that an exception be made so that those savings flow right through to the individuals who need it the most. So that was number one. In terms of the size, in order to get to that 25% savings, you got to have economy of scale. You can't get to it on a 500 kW rooftop. Not even a megawatt system's not going to get you there. Even on the retail side, the most that people are offering in savings is 10 to 15%. And this is good credit folks. So now what we're saying is with low credit folks, we're offering 25%. The third thing is, that's in terms of the small projects. The other thing is this. You're limited by the capacity of the lines. And Steve, I didn't know it was you, I would have said it if I didn't recognize him. You're limited by the capacity of lines of whatever sites you go to. So you're not going to have 1,000 solar farms pop up with multiple co-location sites. However, by having co-location, you have the economy of scale, which buys down the cost of the system. And if you look at how virtual net metering is set up for not-for-profit organizations, it's allowed. So that's how we offer power to Chimes, to Baltimore City Schools, to Christchurch Harbor Apartments, and Supreme Sports Club at a savings because they're all at Nixon Farms and they're all co-located. And what we're saying here is that LMI should qualify for that same type of subsidy. We're trying to get savings to them. It isn't like we're keeping that money and trying to fund more deals. We're passing it on to the individuals who need it the most. And that's why we're looking at that perspective as some kind of waiver. However, going back to what's your name again?
Dan Hurst.
Dan's point, the two provisions, one was, okay, you can't have the same or affiliated ownership. Each project we do, we bring in separate debt and financing for each project. Number one, it's hard enough in the sense that people don't want to touch LMI projects. So to get two individuals who are willing to do it, Fort Meade, right, because Corvius serves veterans housing, they're looking to pass that savings on to veterans who live on base. And then you have Nautilus and Power 52, and we're serving people in the Baltimore Gas and Electric community, especially around reducing the cost of electricity to LMI. The same thing for the system that we have on Raphael Road with Baltimore Gas and Electric. It's aimed at serving LMI customers, and that's all we do. So going back to the capacity, we own 90% of the capacity in the pilot years because no one else wants to touch the market. And so what we're saying is help us to continue to be able to serve the people that the program was created for. And that's our whole perspective. And the way we can do that is by getting the cost down. So in terms of other companies, if they want to serve LMI, 51%, God bless them. They deserve to have access to something like this where they can buy down the cost. I wouldn't say open it to everyone, but I think it's important to get it to the people that need it. The last thing around the request for no net metering, the only reason why I said no net metering because Corvius and Fort Meade don't qualify for virtual net metering. Because they're not a not-for-profit organization, then they don't meet the requirements that are in place for the churches and the hospitals and ag facilities that would otherwise qualify. So that's why we said it wouldn't work from that perspective. Otherwise, we definitely would do it. So that's our request there. And that's it. I mean, I also want to mention that BGE has been very supportive and very helpful. So I don't want it to come across like they denied our application, blah, blah, blah. They stated this is what the way COMAR is currently written. You need to get an official opinion. If that opinion is in favor, then we'll move the project forward, of which all parties are ready. And if it's not, then we do something different. So but I did want to state for the record, they've been very helpful and supportive through this process.
Thank you, Mr. Wallace. At this point, the commissioners will inquire of the panel before us. Obviously, we have a number of parties to this matter, most of whom are not in the room. If I understand this correctly, Power 52 is the developer, but Chorus would be the owner of the project. Is that right?
Corvius. They would own the Fort Meade project. Yes, sir.
Okay. And Nautilus is another project owner. What project would they own?
They would own the Power 52 project. So what we do is each project is its own LLC, and then they invest in the project. They take the tax equity, which buys down 1/3 the cost of the system. They take the SREX to buy down another third, and then the cost of the power service is the last third.
Can I interject for a second? Just to clarify, Corvius is working with Meade Communities, which is the applicant here, and Nautilus is working with Power 52.
Okay, I believe that's what Mr. Wallace said. I may have misinterpreted that. And Sunstone, who are they? Are they another developer? Are they a third developer?
So Sunstone is just the energy advisor for Corvius.
Okay, so they're affiliated with Corvius. Okay.
Are we talking about the project for Frederick Road?
Yes,
you
sir.
talk about these two? Okay, I just want to make sure I know where we are.
Frederick Road and Broadwater.
Okay.
Right, there's Frederick Road, Broadwater, and Howard
But
Street.
are the two projects that we are talking about now specifically for the Frederick Road, the Triple Creek project?
Yes, sir.
Okay,
Yeah.
and Broadwater, we don't have any details at this point. Is that correct for Broadwater? You haven't discussed any specific projects for Broadwater.
Well, so there's two different sites, and each site has multiple projects.
Right, okay.
So Broadwater has two projects. One is Power 52, and one is Corvius. And Triple Creek actually has three projects. One is Power 52, one is Corvius, and the third is for the Boy Scouts. So it's a not-for-profit, and so you can co-locate not-for-profits with community solar currently.
Okay, I'm sorry.
No, that's quite all right. Let me ask a threshold question, Mr. Albert. In your buck sheet on page 4, you mentioned that Meade filed a document on May 16th, 2019. I don't believe the commission has that document, but you represent that Meade stated that they would like to remove the Frederick Road and Broadwater projects from the CSEG program. If that is in fact true, is the request by Power 52 moot?
Well, Mr. Chairman, that's the first thought we had when we got this pleading. Well, our communications have been with Mr. Wallace, and he confirmed to us that Mead is aware of this appeal and this proceeding, and that the fact that Mead has asked it to be withdrawn was just based on the fact that BG&E had rejected the project, but we did not indicate that Mead still wants to pursue this appeal to essentially reverse BG&E's decision.
I don't know if they can. If they, number one, they're not here. Number two, if they've already stated that they're withdrawing from the CSEG program, we no longer have a conflict or issue of co-location that we need to address. There's no live controversy before the commission today.
Well, my understanding is it's perhaps poorly worded on their part. Again, based on my conversation with Mr. Wallace, it was sort of a, given that BG&E has rejected the project, we're withdrawing it, but implicit, but we're aware that there's this appeal out there by Power 52, and if that goes, if BG&E's determination is reversed. But I appreciate we have been in that pickle here.
Right. Yeah. Mead can't have it both ways by saying, well.
Excuse me, Mr. Chairman, I'm sorry.
Please.
But I pulled it up online.
Oh, you have? We have.
From
Okay.
from the official filings, and it simply says, on behalf of Mead Communities, I would like to remove the following two projects from the solar program. They were rejected by Baltimore Gas and Electric due to co-location, and we're not able to complete them. It doesn't say contingent on a filing or we want to come back later. I mean, aren't they? They're now out of the queue. The whole, I mean, isn't that true, Mr. Herson? They would be, now they're removed? I mean, they're no longer.
Well, they were instructed to be removed, right, because it was pushback from Baltimore Gas and Electric. So, but we're actively subscribing for them.
I'm Mr. Bartenfelder. I mean, they are with this letter, which I assume you've seen.
Who is that letter addressed to? Is that addressed to staff?
It's just
of the commission?
the Executive Secretary of the Public Service Commission.
There's two phases. In community solar, the subscriber organization first gets approval for a project from the commission.
Right.
At which point, then they can apply to the pilot program.
Right.
We rejected the Mead applications for these two sites. Then we've heard, and I think what you're saying is then they came back to the commission and withdrew their projects from the commission's approval.
Right. That's where I'm.
So they didn't withdraw from us. We just rejected their application.
Right, but now they have removed themselves from the program based
what
on
it
this
sounds like, yes.
filing. I'm sorry to interrupt you, Mr. Chairman. I just wanted to clarify that there wasn't anything in this filing that said that, unless something else happens or we were going to conditionally approve it unless you change your mind. So
No, I
that's
appreciate that, Commissioner Herman. There is no contingency in that letter that you've brought up, and I have read. I must have just misplaced it. Obviously, Power 52 came first. It was approved by BGE. Mead has come second. They've since withdrawn their request effective May. The Power 52 projects are constructed, is that right?
They're not constructed yet, so we're starting construction. But part of it is having both pieces in place. So we use the economy of scale of both sites to do construction.
Right. That construction's underway, or is
No, it's not. It's not. So we haven't started. We're starting on the first site with Baltimore Gas and Electric about 2 weeks. So we have 7 sites throughout the state that are all LMI projects. I do want to state, though, on that last part, is that Power 52 is the developer for both the Fort Meade piece and for the Power 52 piece. So we own the development rights around all the property. We're doing all the interconnection studies, all the engineering. And Corvius came to us and said, hey, we have some veterans you want to serve on Fort Meade. Can we use one of your sites? And I said, well, as long as you own one and Nautilus owns one, I don't see why it's an issue except for the co-location piece.
So these projects are going forward regardless of how the commission rules today? Your
But
projects?
They can't go forward without being able to co-locate, right? Because I can't put, where else would I put the Fort Meade? So I have to put either Power 52 or Fort Meade.
The Power 52 project, though, will go forward.
I can't make the numbers work. I can't make the numbers work without having multiple sites, multiple phases on the same piece of land, because the interconnection cost is too high, and the 25% we're offering LMI, we can't offer that and pay more for separate projects.
And your entire argument rests on the good causes connected to the cost efficiency of having two projects side by side.
Well, it's not only that. I mean, that's the main thing, because the numbers directly dictates the savings. So we can't offer 9.2 cent power when it's 13.2 cent cost if we don't have economy of scale on the construction side.
Do you disagree with Mr. Albert's statement that if we go down this path, the exception is swallowed by the rule, because obviously any time a parcel has more than one development, there will be an economy of scale and there will be a savings?
Even if it's for LMI, we're comfortable with that. We're happy with that. Non-LMI is something different, but what you see is people don't want to touch that market because the risk is too high. And so that's what we're saying. In order to incentivize that so that we can offer the savings, we need projects and programs like this under the pilot so that we can do that. We're not asking for everybody.
Mr. Wallace, this is troubling based on the correspondence that we have with Mead, and that's all we have, and it's a two-sentence letter. They didn't find the need to send a representative here to speak alongside of you, so...
she was supposed to come yesterday, but her kid got sick, so she sent me an email saying, hey, I can't make it, but let me know if you need me to do something, because she was going to travel here. That's why I pushed it from the 21st last week to the 28th to accommodate her. So I can get something from them saying that or stating that, but they're definitely supportive of the project and the program.
Thank you.
But honestly, I mean, even without them, right, if it's two projects that serve LMI, whether it's Mead or whether it's Baltimore Gas and Electric, we're saying is that they should have the same opportunity that we have for virtual net metering to make sure they get that same savings. But in terms of the Mead piece, I can get that information and she can reinstate and so on and so forth within a matter of minutes. I can call her after this and it'd be here.
We still have a statute on the books. We have the intent of the General Assembly. This is, as you know, it's a limited duration pilot project. There's some recognition of intent that these would be smaller scale, 2 megawatts or less facilities on a parcel, and the proposals that we have before us with Power 52 development would be that there would be multiple projects side by side. Obviously, there are cost savings associated with that, but...
For LMI.
For LMI,
Yep.
right.
Yep.
Does this... Now you'll have multiple megawatt projects side by side in communities. I'm not sure that was what was envisioned by the General Assembly.
Well, they do it now. Baltimore City has a 10 megawatt in Baltimore County. There's a host of them throughout the state.
Oh, sure. Those are utility scale.
They're in utility scale, but they serve separate off-takers that are all not-for-profits throughout the state. So you're not going to have, one feeder can't support 100 solar farms.
It's a different program.
Yeah.
Commissioner Richard, did you have a question?
Yeah, I'd like to understand, maybe it'll help inform what we're talking about for the Frederick Road site. But you mentioned in, I think it was your second filing, you have a discussion about Nixon Farms. And that is you have 3 of the 5 phases completed. And it sounds like in that case you have 5 different unaffiliated owners. Is that correct?
Correct.
Okay.
Off-takers, yeah.
And off-takers, okay. Are you able to do that in that case because all the off-takers are nonprofits? Is that how you're able to do? Okay, so looking at this other project, is it still possible to find the types of nonprofits, or is it that you're trying to actually get into the low and the LMI segment of the CSEGS program?
It's our mission to focus on the LMI, and people always say, well, why don't you open up to everyone? And I just feel like if we don't focus on it, it's going to be washed under the rug like everyone else, and they're not going to have the same access that they need. So to answer your question, we were able to do that at Nixon because it is not-for-profits. It's churches, it's community organizations, schools. And so part of the program that we did the first system back in 2012, virtual net metering, was to get these savings into the corporations and the organizations that are benefiting the community directly. And so that's why Baltimore Gas and Electric waives the distribution and transmission for a virtual net metering project, so that savings can go to these churches who need it.
Yeah.
So the answer is yes. We were trying to do the same thing, just benefiting LMI.
Okay, and I'd note that that project at Nixon Farms looks like it. Well, at least 3 of the 5 phases are up and running,
all 5
and this is right next to the Frederick Road site as well. So your company definitely has established that you're capable of developing these farms and also capable of finding off-takers as well.
Yeah, and I think that the challenge here on these specific ones is just around the community solar piece in itself is so complicated, man. This thing is like everyone says you should just stay out of it. And so what we're trying to do is streamline it so that even after the pilot program, it works for LMI. and that's the goal.
Okay. Hey, just ask the company, at this point, when you're looking at your remaining capacity for, total for the last 2 years in the CSEGS program, have you completed your full allotment, or are you still below it? Are you still looking for projects? And particularly in the LMI, how much of the bucket, if I may call it that, have you filled up for these two categories?
We still have capacity in all of the categories. So the way the program's structured, any capacity that wasn't utilized in year one rolls into year two. We've also had a number of projects that have withdrawn from year one, so that capacity moves to year two. Right now, the capacity we have remaining in the small brownfield other in the current year two, is 9.3 megawatts. We've got 6.4 megawatts in the open category and 13.2 megawatts in the LMI category.
Right. So I guess what I'm hearing, at least for these first 2 years, and we're going into year three, our current regs aren't really working, are they? We're not really getting the projects up and running that the legislature intended for this program to get up and running.
I would say that so. Discussion with a lot of the developers are issues with permitting, issues with navigating the regulatory environment in the local jurisdictions. Say a lot of the projects that have withdrawn are withdrawing because they can't make their 18-month deadline, so they're going to withdraw and reapply.
Okay. And also, I guess, in this case, you have a concern about an interpretation, at least how the regs seem to read, that is holding up several LMI projects. That's what we're hearing today. Is that correct?
Yes.
Okay, so that's a regulation issue.
That's
in
why we
itself.
denied it. It's just
Right, no,
solely based on this.
and
We
that's-
can actually accommodate from a systems perspective. This isn't an issue. I think we can even interconnect those. That's not a question of that circuit being at capacity or our inability to adjust the electric system to accommodate both. It is just based on an interpretation of these regulations.
Right. Okay. So we may not be at least fulfilling the intent of the legislature under these current regulations at this point if we have quite a bit of existing capacity in all categories, and particularly incredibly large in the LMI category. Is that kind of... Can I just ask staff, we do make exceptions. I guess there are 5 different exceptions from the co-location. That's correct, right?
That's correct, yeah. It's specific.
Now, one is actually spelled out. That is rooftop. If it's on rooftop, then there's no application whatsoever to adjacent parcels. Correct?
Yes, I'm sorry,
Okay.
yes.
But we have, I guess, used our authority, our interpretation to look at other categories, such as specifically areas that are zoned for industrial. If it's on a brownfield, if it's along a roadway, if it's in a parking lot. So we haven't necessarily strictly said it's out of the question whether or not we can co-locate these projects.
Right. I mean, the commission,
particularly the CSEGS projects.
Sure, and that's significant. The commission, in prohibiting co-locating, said, well, wait a second, there are some situations where this would be appropriate. We want looser standards, which are spelled out, as you say, in this subparagraph B. So that gives some guidance that the commission was recognized that co-location shouldn't apply across the board. So they said, here's exactly where it would apply.
So it might be good cause as we look at maybe the types of exceptions we need to have. If we have a category like LMI that is completely open, we're completely failing with these regulations to attract projects, that perhaps it would be a good cause to try to relook at what may be going wrong and addressing it. That would be an authority of this commission?
Sure. I mean, because this is a regulatory situation in terms of the co-location restriction, and certainly the commission, as they did here in the regulation themselves, said these sort of situations we're comfortable with co-location. The commission could revisit that and expand that, looking specifically. Mr. Wallace puts forth, from a public interest perspective, we appreciate that's a compelling story. But we see, we're in a situation where we see a public interest story that's bumping up against commission policies.
Right. Or at least something
And the
we-
legislature, for that matter. And I would note, correct me if I'm wrong, I think each of the 4 projects, the 2 Mead projects and the 2 Power 52 projects, are 2 megawatts.
Correct, yes,
Which
sir.
is the max. So there's a concern about co-locating. Now it's not, instead of 2 megawatts on that site, it's 4 or maybe 6 or maybe 8. That does trigger a concern on staff's part in terms of was the legislature contemplating these larger 10 megawatts, 20 megawatts on a specific parcel.
Okay, and for if we were to want to act and try to get some of these LMI projects up and running, is granting a waiver something that we could do? In this case, is that the best approach to trying to, again, facilitate these types of...
I think the commission certainly has that authority to grant that waiver. If the view is that the public interest aspects, as presented by Power 52, overweigh these other concerns.
It seems like the legislature's already said it's in the public interest to have a successful program, and particularly to have LMI participants. So, great, thank
That's
you.
certainly the commission's call.
All right, thank you.
Commissioner O'Donnell.
So to staff counsel and along those lines, isn't it also true that the regs may not be the only bar to development of LMI projects in the CSEGs? In other words, it may be financing or the risk aversion of financiers or developers, as Mr. Wallace indicated. There may be many other reasons, a myriad of reasons, why we don't have development in there besides a perceived deficiency in the regulations.
That's right, and I think Mr. Wallace is saying this is, the reason they jumped into this niche, and it's admirable. They're saying people don't want these customers. It's a higher risk.
Yeah, so
And,
the risk is probably the main driver, I think, Mr. Wallace. And the work you're doing is admirable because you're saying, I'm willing to accept that risk for the benefits, and I
Yeah.
appreciate that.
And the state's helped a lot too, man. Like Maryland Energy Administration has been very helpful in like helping educate communities and participation because the community's been taken advantage of so long. Now you bring a new program. It's like, what's the catch? Like, I say 25% for doing what? Nothing. What? Month-to-month contract? This doesn't sound right.
Sure.
And so we're dealing with the whole education piece as well.
Sure.
On
I appreciate
top of
that.
Yeah.
Besides the list of the enumerated exceptions on co-location, have we issued any exception or waiver of the requirement of co-location in CSEGs? In other words, have we authorized 2 other megawatt projects to be co-located on the same parcel?
I'm not aware, if I could, indicated by staff that we have not had this.
So were we to
granted
do this in this instance, we would be setting precedent?
Yes.
And we would probably have an ever-ending stream of waiver requests coming in to co-locate these things, in my opinion. But we do have a pending round of revisions to the CSEG regs coming, don't we? Isn't that on the horizon?
That is my understanding, that process has already, I've consulted on that, and I was aware that we do have that process going.
So instead of setting precedent with a decision on this instance, might it not be better to take a more measured approach through the regulatory process and the rulemaking process so that we're not ruling by exception in a particular case, but we're doing what makes sense so that we can help the Mr. Wallaces of the world get over the hurdles that may or may not exist in the regs, but take into account other stakeholder concerns and considerations. For instance, the legislature, not a minor consideration, right, who may have had a desire to spread these things around the state and not have them concentrated only in certain areas. Would make that not be the better approach to take with regard to setting of rules?
Yeah, I think especially given the fact that process of a rulemaking has already been initiated. I mean, rulemaking does have the advantage if everyone comes to the party. I mean, everyone gets to have input on it as opposed to a specific project, a specific proposal where no one else is opining on this. So yeah, given that the process, the generic rulemaking process has been initiated, I think that would be a better place to really vent through these concerns. Power 52 does point out this is the LMI sphere is not one. It's difficult to attract projects in that sphere. So that may well be a situation where the commission, having a list of exemptions scenarios, would consider whether expanding that list specifically for LMI and any contours they'd want to put on it.
And as worthy as this appeal may be, the slippery slope of never-ending requests of waiver because, well, you've already set precedent in that area it eats up a lot of resources, doesn't it? As I've indicated earlier today, of staff and many other agencies in the state. If you start getting a never-ending stream of waiver requests instead of having your rules set appropriately, is that not true?
Yeah, I think that's certainly true. Whenever you go the exemption route, it's going to trigger more requests, and you certainly see that with the curtailment penalties. It's now essentially by default being dealt with in an exemption situation.
Can I add to that? Yeah, so I would agree in theory. My concern, though, is that we're in year 2 of a, I guess, 3-year pilot. There's no LMI projects that have been built yet, and you have the tax equity value going down every year we push this back. So if it takes another 6 months, a year, now we lost 2019 tax credits. We're in year 3 of the program, and we're still not going to have systems built. So that's my concern there, is that once you get these 2,000 people who influence the community solar advisory group, which is too many people, number one, it's going to get pushed around. The second thing is around the timeline is that these projects that we're trying to put in place, there's plenty of capacity for LMI, but if we make it contingent upon co-location of LMI only, you're not going to have all these people applying because they're not going to be able to get it done. And if they can, then great, it helps more people. I mean, that's the purpose. You heard them say we don't have enough projects for LMI. So like if they can do that and this incentivizes them to submit more, then God bless America, we're doing what we're supposed to do. And so that's why for us it's such a big deal, because time is of the essence, man. Like how many LMI projects have been built? Like we're building the first one now. And so it's like literally we're ready to pull the trigger on these projects and start. This is like the last piece. And so I understand, and I'm not trying to create more hardship for the PSC and the hours spent, but I do think it's important that we do set precedents around this is important. This is the purpose of the program, was to serve LMI. And if we don't show that, then you're going to constantly, it's going to be pushed under the rug, kind of like everything else was. I will say though, the reason why you're having those issues is the time frame to get a project up. 12 months is too short. And I suggested that to Phil when we first went through this process, because the counties are not 100% on board. So you spend 12 months just dealing with the counties, then 6 months in development. Now, I'm from Howard County. I live there. That's how Howard County is our friend. Baltimore County is our friend because our school was there in Baltimore City. So that's how we make these counties work quickly. Otherwise, the projects time out, and that's what you're seeing with Forefront, and you're seeing with some other companies, renewables, because the time, 12 months is too short. You spend 6 months in just appeals, so just wanted to add that piece. But thank you for hearing and my main thing was to have it heard. I think it's important for them to consider whether or not it's addressed today, our preference is today, but more so, how do we adjust policy going forward so that when the program actually rolls out after the pilot, it's a success. And that's the goal of what we're asking for.
Thank you, Mr. Wallace. Commissioner Herman.
So, Mr. Wallace, you just mentioned something that I was going to ask you about. The Meade projects, which have been withdrawn, but those projects, they were not LMI projects, were they?
They are LMI. So it's funny, right? Because LMI is low and then moderate income. So low is like under like 33,000 a year.
That's like 30%. The LMI category is 30%, and then the other is more than 51%, I believe, right? I believe that's correct.
LMI on ours is 51%, and then 49% can be others.
Right. But what is Meade?
Well, Meade's LMI. So it's an other program, because most people that are retired veterans don't make more than $60,000 a year.
But I don't see anywhere in the paperwork here, Mr. Albert. I looked on the buck sheet. I noted that one of the Meade projects was going to serve people on a military base, but that they're not necessarily low income customers.
Right, that's my understanding. Maybe Mr. Wallace can clarify that, but all along I viewed Power 52 as LMI, and Meade as for military veterans. But I think Mr. Wallace...
Yeah, but their category in the community solar was the LMI category, I believe. Because there's two categories. LMI is 30%, and then other is more than 51%.
Is more than 51, right. Exactly. Yeah, that's what I was saying. So,
there's the two Meade ones are LMI, which is 30%, right? But if you look at the demographics of the people on our base, like no one's making $100,000. I mean, they're all...
that may be, but the LMI is 30%, and then you're the other, which is more than 51%.
Yes, ma'am.
So, is that true of both Meade properties?
Yes, ma'am. Both of them would serve the Fort Meade housing facilities.
Okay. That's helpful, because that wasn't clear in the paperwork, so that helps me out. I will say, Mr. Wallace, I think it sounds like you all do wonderful work, and I think it's great. But I will say that I have significant concerns from a procedural standpoint because Mead has already withdrawn its request, and therefore I don't see how we can rule on a co-location. Mead isn't here. I understand that you've been in communication with them, but they're not represented here, and so I think it's very difficult from this commissioner's standpoint to rule on something that's not procedurally before us, and so that is a significant concern on my part, and therefore it's difficult for me to say, that a waiver is even appropriate because I don't have anything to waive because I don't have Mead in front of me, because they have withdrawn. So from a procedural standpoint, I see a deficiency that it makes it difficult for this commissioner at least to overcome. And I agree with Commissioner O'Donnell that we do, if there are indeed pending discussions related to the community solar regulation and the pilot, which I thought had been extended. Yes? Yeah, 7 years. So I think we have a little more time than 3. So it's been extended to 7 years. So this may be a time to discuss other issues, including this issue and other issues that we've seen with community solar before this commission. So that's my position, Mr. Chairman.
Thank you, Commissioner Herman. Commissioner Linton?
Thank you, Mr. Chairman. I had a question regarding the status of the Power 52 project after today. So, and maybe not necessarily after today, but just at some point when the commission has issued a decision on the interpretation question. If the co-location is not allowed, I think it's fair to say that the economies of scale don't work for the project.
Correct.
If the co-location is allowed, but Mead is withdrawn from the project currently, is it the understanding or expectation that they would participate again?
100%. I could probably get on the phone right now and put it on speakerphone if that helped. We literally talked yesterday. We talk once a week on the project status, and I have a call with them at 2 o'clock today.
Okay, so there's already been some amount of investment that's been made towards going forward with the project under the concept of it being co-located.
Correct. I mean, each project costs us about $100,000 to get through development. So for each one of those projects, we have about $100,000 in them in terms of land, preliminary interconnection, preliminary engineering studies, the whole 9 yards, legal fees. Yeah.
And so if the commission chooses instead to move forward with a change to the Code of Maryland regulations because we quite frankly, there's several issues we have to address because the program has been extended by the General Assembly. If we move forward on that approach, as we all know, the COMAR modification process could take a year, depending on how many changes we want to make and how many parties would like to participate. It could take a year and a half, et cetera. And the regulations are then adopted at that point, and then to the extent there's any system changes utilities have to make, any industry issues that have to be addressed, those will take additional time. Let's assume, for purposes of today, that we're looking at a year from today. What happens to the 2 projects that we're talking about now? Are they still viable?
I kill them. They've already asked me for additional deposits on the land for $50,000 because of the first extensions. So I would have to kill them and start. Good question, but they wouldn't be able to go forward. The time kills all deals. I mean, we're already almost 2 years in development on. I think how long? 2 years ago. The Broadwood and it might be maybe a year and a half. I mean, a substantial amount of time. But I can't afford to bear any more of the cost about being able to turn some of these things on. This is too expensive. The carrying cost is too expensive.
Okay, thank you.
Mr. Walsh, did you just say, does Power 52 currently own the land that it seeks to develop the solar panels
No,
on?
so, but we do like leases, we do 30-year lease, we have to put deposit after deposit after deposit every time we extend it. Of course, they didn't farm this year, they didn't plant soybeans, didn't plant corn. So the hold costs of all the landowners is what eats us up. Because until we can get to a lease where we turn the system on and now they get $2,000 an acre per year for 30 years, then that's when they go sit down. But until then, they're losing money and we're losing money.
Have you executed these leases?
Yeah.
Okay, so so you have an option, or
It's all contingent upon this co-location and finalized. It's only the ag preservation payments just went live August 3rd, August 15th, so we're ready to go. This is the last piece.
Okay. You obviously have a very admirable mission here in what you do to support these
It's tough, man.
communities.
Sometimes I ask myself, like, what were you thinking? Like, why did you? I should have just stayed in Northrop Grumman.
I am concerned, though, for the reasons that were raised by staff counsel and the fact that we do have a rulemaking proceeding underway. I recognize that rulemakings take the time, as Commissioner Linton noted, and a considerable amount of time. But because of the procedural posture of this case, I am not comfortable with making precedent here. I believe we need to take a more measured approach. If we do allow an exception of co-location in this proceeding, I suspect we'll have a flood of applications, and it hasn't been thoroughly considered by this commission what the effect would be. Are we thwarting the intent, or are we supporting the intent of the General Assembly if we allow the co-location of solar facilities on single parcels? As Mr. Herson noted, the four-pronged provision of Comar 2062 3.8 is clear on its face right now, and that is our regulation. So if it's going to be changed, it's going to be changed by this panel. So for that reason, I unfortunately cannot support the request for advisory opinion that Power 52 has made today. Do commissioners have any final thoughts or comments? Yeah, we're going to take a vote. Yeah, well, we're going to... Yeah, if you have a statement, otherwise we'll take the motion on the vote on the motion.
Oh, okay. Well, with that, yeah, I would be in favor of supporting a waiver today, and I agree fully that we have this rulemaking, and we need to correct a lot of issues in that rulemaking, and I think that's going to be a great opportunity to do that. But, I mean, as we heard today, time kills all deals, and at this point, we are actually going 3 years into the program, and we have no LMI projects in Baltimore Gas and Electric, and I believe it may be very few, if any, in Pepco either. So our current regulations are failing in the LMI category and in some of the other areas as well. So rather than, again, saying, oh, we'll wait for this rulemaking is very important. We need to correct a lot of things. But we have a problem now to solve. We are not carrying out, I don't believe, the will of the legislature if we show, at the end of year 3, and we have big parts of our state that don't have any LMI projects. So this seems to be a good opportunity before us to go ahead and jumpstart that process. We've heard that it is a legal remedy from our staff counsel, and so I would strongly support moving and taking action today to provide those waivers to allow projects like the ones we've heard about today to get going. We have a huge challenge for this day. We're supposed to have 14.5% of our electricity come from solar by the end of 2030. That's about, our staff tells us 5 gigawatts. That's about 25,000 acres worth of solar. So if we have a lot to do, so I don't think we can risk losing any of these projects, particularly one that's in the public interest like we've heard today for low and moderate income. So.
Thank you, Commissioner Richard. Commissioner O'Donnell.
Thank you, Mr. Chairman. I will just say this. It pains me to come to the conclusion I'm coming to because this is such a worthy process, and I find it unfortunate. But my concern with setting precedent without having all of the other parties, nobody's going to come into this proceeding today and oppose this project. They'd have to have it'd have to be crazy because it's a good worthy project. So we may not be hearing all of the concerns of all of the stakeholders that are out there. And so for that reason, I think we have to wait until the adjustments to the rulemaking process occur later down the road. I don't know what that will produce because I don't know what we will hear through that process, but it's the due process that allows everybody to come to the table instead of setting precedent today. And as painful as that may be for us and for me and to this particular project, I think it's the right thing to do. So I'm going to be I'm going to move to deny the request for a waiver from the co-location requirement, which I think is the only question before us today after everybody has a chance to make their statement.
Commissioner Linton.
Thank you, Mr. Chairman. As we all know, a request for a waiver of COMAR, especially in scenarios where there's not a specific categorized reason in COMAR for the waiver, is in a situation that's unique where the regulation was not necessarily designed to address that particular scenario. And they can be not just unique, but they're focused on an individual entity or a situation that's in front of the commission at the time. I personally don't think of waivers as establishing a precedent for other parties to do the same thing. And for purposes of this, if we had a number of other parties coming in looking to co-locate for LMI customers or LMI projects under community solar, that might actually be a good problem to have because we don't have that challenge now. But I'm concerned that we're sending a negative signal at a time when we've improved our RPS, increased our RPS and our carve-out for solar, and we're effectively, as we've heard this morning, ending a project that is specifically designed to serve LMI customers. I think that we're at a midpoint for our community solar program. It was just extended by our General Assembly for another, I guess, 4 more years. We know that our rulemaking process is going to take at least a year and a half, and hopefully at the end of that we'll have additional projects that will come out for LMI or however LMI is structured at that point. But we don't know that we will. And so I feel like we're missing out on an opportunity not just to take advantage of the good work of the Power 52 Foundation, but we're ignoring some lessons that people in the solar industry have told us regarding challenges to work with our local governments, challenges to go through the permitting process, and the challenges that they've had in the short amount of time necessary to grant a project. Here we have one project that's ready to go. We have investment that's made. Our utility companies have made clear that it's not an issue of technology or of capacity on their system. It merely is a question of how we've drafted our regulation and how we've interpreted it. And I think it's unfortunate that we are effectively ending a program or a project that would have assisted a number of low-income customers, moderate-income customers, and veterans. So I would have voted to approve the waiver request.
Thank you, Commissioner Linton. Commissioner Herman.
Well, I'm going to split the baby, but it results in an effective denial of the waiver. I do think that it might have been possible to have had good cause granted here for a waiver, but Meade isn't here. Meade isn't an entity. Meade has withdrawn, and therefore it's procedurally I can't rule on good cause because I don't have 2 entities here asking for co-location. I have one, and I don't have the other. So I can't say for sure because Meade isn't here, and I haven't had the opportunity to discuss this with Meade to understand their project in full. But from my standpoint, it has to be no because I don't think I don't have I don't have 2 entities making the request here. I have one, and it's not that I don't believe you, and I do, but from a legal standpoint, I have a procedural deficiency I can't get over. So again, I hope you continue your good works and are able to move forward with projects in the future and as soon as possible.
Thank you. Is there a motion?
Mr. Chairman, I move the commission deny Power 52 Foundation's request for a waiver of Comar 20.62.03.08.
All in favor?
Aye.
All opposed?
Aye.
By a vote of 3 to 2, the motion is approved to deny the waiver. Seeing no additional business before this commission, this meeting is adjourned.